Good morning, everyone, and welcome to the Collaboration for Nonprofit HR Professionals annual fourth quarter legal update sponsored by Thompson Hine. For those of you who are new to the group, the collaboration was founded in 2013 as a way to connect nonprofit professionals responsible for HR in their organizations and provide opportunities for education and resources that help build the capacity of each organization's HR strategy. We hope that in 2022, we can gather everyone in person again, as we did for our pre-pandemic quarterly events. I'm Julia Love. I'm a partner and the practice group leader for Thompson Hine's Employee Benefits and Executive Compensation Practice Group. And we're pleased to present to you this morning the 2021 Employment and Benefits Legal Update. Throughout the presentation, we ask that if you have questions, you enter them in the chat, or if we're not able to get to your questions today or you don't put them in the chat, feel free to email one of the presenters. I believe our contact information is in the slides. I'm going to speak first and provide an employee benefits update, followed by an associate in our tax group, Alexis Kim, presenting on benefits taxation and remote work tax. Then we're going to have a short break, probably around 10:15 or 10:20, and commence again at 10:30. For Nancy Barnes to present an employment law update. And Nancy Barnes is a partner and also the practice group leader of our labor and employment group. And then finally, we're going to have hot topics in employment law by Hannah Caldwell, who's an associate in our labor and employment group. So getting right to the fun topic of benefits. This morning, I'm going to present a health and welfare plans update, including COVID-19 vaccine incentives and surcharges, COVID-19 testing considerations, year-end amendments for health and welfare plans, and then Consolidated Appropriations Act compliance. When I finish with the health and welfare section, I'll then move to retirement plans update, including year-end amendments for retirement plans, cybersecurity guidance, missing participant guidance, and then some action items looking forward to 2022. So jumping right in, this is a very hot topic right now, as I'm sure Nancy will be discussing later. We have the OSHA ETS, which requires employers that have 100 or more employees to provide either that their employees must be vaccinated or they could provide a COVID-19 testing alternative. And I know a number of our participants today probably have less than 100 employees, so you may be looking for other ways to incentivize your employees to get vaccinated. So what can you do to provide incentives? And really the legal framework around incentives for vaccinations, or really any incentives, depend on three things. One, are you solely providing, or you're solely requiring your employees to provide proof that they've done something, in this case, get a vaccination? Will that something, in this case the vaccination, be administered by a provider under contract with the employer or by the employer itself? Or will the incentive be offered as part of the group health plan? And the answers to these questions will dictate what legal regime you fall under in offering in this case, a vaccine incentive. So I thought it would be helpful to walk through some examples in order to understand the legal framework here. So in our first example, the employer provides a gift card if the employee simply shows proof of administration of the vaccine. So in this case, there's no connection between the group health plan and the incentive, and therefore you're not subject to the wellness program regulations under HIPAA. I think a lot of you are familiar with those requirements because we've talked about them in previous legal updates. Additionally, you're more than likely not subject to the wellness program regulations under the ADA because you're not providing either a medical exam or inquiring or making a disability-related inquiry. You're simply asking the employee to show their vaccination card to receive the incentive. So in this case, really the only thing that you have to keep in mind is that if you provide a gift card to employees, that gift card is taxable, or the value of the gift card is taxable to the employee. And I think Alexis may talk about things like that in her section. In the second example, similarly, the employer is providing cash to employees if they receive a vaccination from a provider under contract with the employer. So again, we don't have the group health plan involved, so we are not subject to the non-discrimination rules under HIPAA for wellness programs. However, in this case, the employer is making a disability-related inquiry. More than likely, when the provider who's been engaged by the employer asks the questions about whether an employee can receive the vaccine, do you have a health condition that would prevent you from receiving the vaccine? Have you received another vaccine within, 30 days or whatever the requirements are? Those are disability-related inquiries and therefore would subject you to the requirements under the EEOC for voluntary wellness programs. You may also recall that in 2016, there was a lawsuit, the AARP versus EEOC, which the subject of the lawsuit was whether the incentive limitations under the EEOC's final regulations regarding voluntary wellness programs were arbitrary. And the court held that they were arbitrary and therefore vacated those rules. So we currently do not have a safe harbor to determine what level of incentive could be provided that would satisfy the ADA safe harbor rules. You might have guessed, in our third example, we are providing a premium, either surcharge or incentive to medical plan participants who do not, an incentive if you provide proof of your vaccine, or a surcharge if you do not provide proof of the vaccine. And, just kind of a note that both the department or the HIPAA rules and the EEOC rules would say that a surcharge and an incentive are two sides of the same coin. So the analysis is exactly the same if you provide an incentive or if you provide a surcharge. But regardless, the regulators earlier this summer told us that a vaccine surcharge program in connection with the group health plan would be considered a health contingent activity only wellness program for purposes of the HIPAA non-discrimination rules. And what does that mean? First and foremost, that means that the value of the incentive cannot exceed 30% of the lowest cost option of single-only coverage offered by the employer. And just as a reminder, that limit increases to 50% if you have wellness programs that relate to prevention of tobacco use. Also, because you are a health contingent wellness program, but it's activity only, you have to provide a reasonable alternative or a waiver for individuals for whom it's unreasonably difficult or medically inadvisable to obtain the COVID vaccine. An example of a reasonable alternative may be that you have an employee attest to complying with the CDC's mask guidelines for unvaccinated individuals. And I think, one pause here is, how on earth is the employer going to monitor that? I mean, you may be able to monitor that in the workplace, in compliance with the OSHA ETS or otherwise, but you really aren't going to be able to monitor that in the employee's day-to-day life. However, if you're offering reasonable alternatives, you can also require the employee to provide verification from their physician as to why obtaining the vaccine is unreasonably difficult or medically inadvisable. If you do that, though, you have to accommodate the opinion of the employee's personal physician, and you have to provide a reasonable alternative that accommodates the recommendations of that physician. And finally, all materials describing the vaccine incentive or surcharge must include notice of the availability of the reasonable alternative, including contact information, and a statement that recommendations of the employee's personal physician will be accommodated. And I'll just note that these requirements are not new. They are, again, part of the HIPAA non-discrimination rules, which have been in effect for quite a while. And if you have wellness programs, hopefully you're already satisfying these requirements if they're subject to the HIPAA rules. Additionally, the wellness program must be reasonably designed to promote health and prevent disease. I'm having a hard time getting that word out of my mouth. And the reasonable alternative cannot be overly burdensome and should be designed to prevent infection with the virus that causes COVID-19. And finally, the program must be given, individuals must be given the opportunity to earn the reward at least once per year, and that's a calendar year or plan year. And again, think about that. If you're offering a COVID-19 vaccine incentive or surcharge, what's that going to look like? If people are vaccinated for 2021, how are you going to offer the incentive in 2022, et cetera? Another thing to keep in mind if you're including a vaccine incentive as part of your group health plan by varying premiums based on your vaccination status, you have to keep in mind the affordability safe harbor under the Affordable Care Act. If you're an employer who's subject to ACA reporting, mandatory employer reporting. In the early years of reporting, the reporting was limited to employers with 100 or more full-time employee equivalents, but once the rules were fully implemented, that number was reduced to 50. So some of you may be subject to ACA reporting. And if you are, you have to take into consideration that the vaccine surcharge is determined as if nobody meets the vaccine surcharge in determining the affordability of your group health plan. And remember that when you determine affordability, you're looking at whether the total cost of your lowest cost single only option that you offer to employees does not exceed, for 2021, it's 9.5%. And for 2022, it's 9.61%. And you can choose from 3 safe harbors. One is the employee's W-2 compensation. The second is the federal poverty line income limit. And the third is the rate of pay safe harbor. So if your base premium plus the tobacco surcharge does not exceed that 9.5 or 9.61% of either W-2 earnings, rate of pay, or the federal poverty line, then you would satisfy the affordability standard. And just a note here, you'll see the tobacco surcharge in the table at the bottom of the slide. The regulators have said that you can always exclude the tobacco surcharge or deem everyone to have satisfied the requirements to not have the tobacco surcharge applied to them in determining affordability. So what should you do if you're considering offering a incentive to for people to become vaccinated? You need to determine how you're going to address ERISA, COBRA, and HIPAA requirements if the vaccine program is a group health plan in and amongst itself. And we're going to talk about that in just a minute. And also, you're going to want to consider if you have compliance obligations for flu shots. So a number of employers have provided flu shots to their employees on site just as a easy mechanism for people to obtain those flu shots, and nobody really thought about it. But now with the guidance coming out with regard to COVID-19 vaccines, basically a similar analysis applies, and you'll want to consider whether you have group health plan requirements relating to your flu shot program as well. And then finally, if you're going to provide incentives for employees to obtain a vaccine, make sure the design of the incentive program complies with the applicable laws. And we talked about the HIPAA requirements. The EEOC non-discrimination requirements or voluntary wellness program requirements are very similar to the HIPAA requirements, with the exception of we're not sure what the safe harbor for the incentive is, because that was vacated by the courts, as I mentioned earlier. So many employers probably attending this webinar are not subject to the ETS, the OSHA ETS, because you don't have at least 100 employees. But you still may want to encourage your employees or provide a mechanism for your employees to be tested if they're not otherwise vaccinated. And a question that has come up a lot with our clients is, can an employer pay for COVID-19 testing for employees who are not part of the employer's group health plan? And just as a reminder, the group health plan requirements only require group health plans, to get or to pay for COVID-19 testing if an employee has symptoms and a doctor recommends that they be tested for COVID-19, or if the individual has been exposed to COVID-19 and a physician recommends that they be tested for COVID-19. So there is no group health plan requirement that you pay for testing. I think for employees who are covered by your group health plan, you probably could amend your plan to provide that the plan would pay for COVID-19 testing. Of course, if you're a fully insured plan, you'd have to get the insurance company on board with that, and that may cause additional premiums. And if you're a self-insured plan, you'll want to ensure that your stop loss coverage will also not be violated because you've added this additional requirement or additional coverage item that's not mandated by essential health benefits or anything else like that. But regardless, a lot of employers are asking, what can we do to pay for COVID-19 testing outside of a medical plan? Does this create a new group health plan? So group health plans are ERISA welfare benefit plans that provide medical care. And certainly, I think most people would agree that the provision of a vaccine is some form of medical care. But the other requirement is that in order to be a ERISA plan is that there's an administrative scheme in place, or there's a plan, fund, or program in place to provide whatever benefit that you're going to provide, in this case, COVID-19 testing or COVID-19 vaccines. And I think that if you are simply providing COVID-19 at-home test kits for your employees, for example, you stick them in the break room next to the coffee machine and people can access them, that's probably not an ERISA plan. But if you're proctoring self-tests or you're engaging a service provider to proctor self-tests, consider whether you have an administrative scheme, and I think likely you do, and you would have an ERISA plan, fund, or program that's subject to the ERISA requirements or ERISA and code requirements applicable to group health plans. So one way that employers can provide COVID-19 testing or really COVID-19 vaccines to their employees who are not subject to the group health plan is to create a COVID-19 testing EAP or COVID-19 vaccine EAP. And the regulators earlier this year came out and said, if you provide testing or if you provide vaccinations to your employees under an EAP, that would not cause your EAP to lose its accepted benefits status. So what is an EAP that it has accepted benefits status? It's an EAP that does not provide substantial benefits in the nature of medical care. And this is really important and a really valuable thing for employees, because if you have an EAP that does not provide substantial benefits in the nature of medical care, you're not subject to the market reform provisions of the Affordable Care Act. And that means that you don't have to worry that you have a group health plan that doesn't provide preventive health services with no cost sharing. It doesn't satisfy the essential health benefits provisions of the Affordable Care Act, et cetera, et cetera. So you can simply provide either COVID-19 testing or COVID-19 vaccines pursuant to this EAP, and you don't have to worry about, having a health plan that doesn't satisfy the Affordable Care Act. It doesn't, however, accept you from the other requirements applicable to group health plans, including ERISA, COBRA, and HIPAA. So how do you satisfy these ERISA, COBRA, and HIPAA requirements? So for purposes of ERISA, basically the requirement is that you have a plan document, a summary plan description, you file a Form 5500, and you have claims and appeals procedures. And I think most employers already have some sort of an EAP that's part of a WRAP plan. So they have plan document, SPD. If you're subject to the Form 5500 requirements because you have more than 100 covered lives, maybe you're already filing Form 5500, you would just simply include this benefit as part of that. So, to make a long story short, you would amend your plan to reference this new benefit. You would amend the SPD to reference this new benefit. You're either filing Form 5500 because you have more than 100 covered lives, or you're not. And the plan document more than likely already has claims and appeals procedures. COBRA seems to be something that a lot of employers get wrapped up in. And why would you offer this COVID-19 testing option for an employee who's no longer in your workforce? And I think it's, write your congressman. That's just how the law works. If you're a group health plan, you have to offer COBRA continuation coverage, right, or COBRA continuation coverage. And I think for purposes of an EAP, you can satisfy this requirement by simply providing this EAP coverage through COBRA at no charge to the employee, and include information about the COBRA coverage opportunities in the plan document and the SPD. In that case, you don't have to provide a notice or any kind of election to the employee, and I think you'd get very little take-up. If you're concerned about getting take-up for this EAP, you could consider charging for coverage. However, if you charge for coverage, then you have to provide notice and an election right for that EAP COBRA continuation coverage. And lots of employers really don't want to get into that because they already have a vendor who provides COBRA notices for their medical, dental, and vision plans. but they don't have a mechanism to provide the notice and election for this EAP. So, think about that as you're designing your program. And then finally, for HIPAA, HIPAA prevents the employer from receiving protected health information except for payment, treatment, or healthcare operations, which, providing or receiving proof of somebody's vaccine status or testing results would not satisfy those requirements. So in order for the employer, if you want to know the results of an employee's test, which you would need to satisfy the requirements of the OSHA ETS, or if you just want to know it for purposes of monitoring people that are coming into your offices, you can either have the employee sign a waiver so that the provider can provide the results to the employer directly, or you can have the employee provide the results directly to the employer, and that way you wouldn't have any HIPAA issues. So moving on to year-end amendments for health and welfare plans. You'll see this chart lists a lot of changes that were implemented by the regulators as a result of the COVID-19 pandemic. And a lot of these requirements have a deadline to amend the plan by the last day of the 2021 plan year, December 31st, 2021 for calendar year plans, and be the end of your 2021 plan year if you have a non-calendar year plan. And I recommend that you take a look at these permissible changes and determine whether you implemented any of them in 2020 or really 2019 into 2020, and whether your documentation needs to be amended to reflect these. Just as a reminder, the general rule for health and welfare plans is that amendments can only be prospective. So these are special rules that allowed employers to make retroactive amendments for things that they did earlier in a plan year. And so this is special relief, and you want to note these deadlines. And just as an example, many employers have medical flexible spending accounts or dependent care flexible spending accounts. And when the pandemic hit, or so employees made their elections probably during open enrollment in 2019 before anyone had heard of COVID-19. And in 2020, they weren't able to access healthcare. Doctors' offices were closed. Daycares were closed. Et cetera. So you weren't able to use the dollars in your medical flexible spending account or your dependent care flexible spending account. And so these rules provide flexibility. If the employer wanted to, they could have extended the grace period from 2019 into 2020, or there in some cases, if you have a carryover in your flexible spending account, you could increase the amount of the carryover to the full value of the account at the end of the prior plan year. So this is very favorable guidance and could be very helpful to your employees. And if you implemented any of these changes, you should make sure you adopt the amendments by the end of this year. Or there's some towards the end of the slide that are amendments for 2021 plan year that have to be adopted by the end of next year. Other group health plan things I just wanted to note is that during the early part of the COVID-19 pandemic, the regulators said that group health plans could cover the cost of telehealth and other remote healthcare services without cost sharing. And this was especially important if you have a high deductible health plan design. They said it wouldn't cause your high deductible health plan design to fail to be a high deductible health plan. That guidance is sunsetting as of December 31st, 2021. And so, you may want to amend your plans or advise your participants that that's no longer going to be the case in 2022. And no sooner than I get those words out of my mouth than I remember that yesterday I saw a news article that the Congress is considering an extension of this telehealth guidance. So stay tuned on that. And the last thing on health and welfare plans that I want to mention is that early in the pandemic, I believe it was April of 2020, we had the Department of Labor and the Department of Treasury issue COVID-19 extensions. And these extensions run from March 1st, 2020 until 1 year, or for a period of 1 year, or if earlier, until 60 days after the announced end of the COVID-19 pandemic national emergency. And the extensions apply to HIPAA special enrollment rights, COBRA election payments and notice, and claims and appeals deadlines. And of course, when the extension was first announced in 2020, nobody thought the pandemic was going to last that long. So round about the end of February 2021, the regulator said, well, what are we going to do? The pandemic isn't over yet. How can we continue to provide the American workforce with these valuable extensions? So instead of just having everything run from March 1st, 2020 till February 28th, 2021, the regulator said, no, each individual action now has a extended deadline from the date it would have otherwise occurred until 1 year after, or if earlier, 60 days after the announced end of the COVID-19 pandemic national emergency. So just as an example, if I have a HIP or a COBRA qualifying event and I'm entitled to COBRA continuation coverage, and let's just say my qualifying event happened on July 1st, 2021, normally I have 60 days from the date I received notice. Let's just say my employer provided me notice on the date of my termination. So I have 60 days to elect my COBRA continuation coverage. I now have 1 year and 60 days to elect my COBRA coverage. Unless the pandemic ends before that 1 year period, in which case I have 60 days of my election period plus 60 days plus the end of the national emergency. So long story short, these are pretty complicated to understand. I'm not aware of a lot of employees taking employers up on these extensions. For example, if I need to elect COBRA coverage, I'm going to elect it and pay for it because I'm not going to be able to use my benefits card at the doctor if I haven't paid for my COBRA coverage. So I would just say, be careful of these deadlines extensions. I think there may be people out there who are waiting to take advantage of them and maybe not, but they're complicated and difficult to understand. The next topic is some Consolidated Appropriations Act compliance items. So you may be aware that at the end of December of 2021, Congress passed the Consolidated Appropriations Act, which had a number of group health plan mandates in it. The first one that I'm going to talk about is surprise medical billing. So part of the Consolidated Appropriations Act is a bill known as the No Surprises Act. And basically, the No Surprises Act is intended to eliminate balance billing for group health plan participants who receive emergency out-of-network services, or if they receive non-emergency out-of-network services provided at an in-network facility or hospital, or if they receive out-of-network air ambulance services. And basically what the surprise billing requirements are that the employee would pay basically no more than what they would have paid for an in-network service, and the provider gets paid an amount that's determined by the group health plan to be, a reasonable reimbursement, and there's no balance billing. So the provider has to accept the payment by the plan or the provider or the third-party administrator, and they cannot then go after the participant for any remaining amount that they feel is undue. And the amount that is paid to the provider is determined by either the plan or the third-party administrator. And if the provider doesn't accept that payment, the parties have to negotiate. And if they can't come to agreement, then there's an independent dispute resolution process. And I think for a lot of people who are participating today, you have an insured medical plan. I recommend that you discuss with your insurer that they're putting these provisions in place and updating their certificates and communications to participants so that they understand how this is going to impact them in 2022. And if you're out there and you have a self-insured plan, you similarly should be discussing with your third-party administrator whether they're equipped to handle this for you beginning in 2022. Also, part of the Consolidated Appropriations Act was a number of transparency requirements for group health plans. And you may recall back in 2020, there was also final transparency regulations. And a number of the provisions in the Consolidated Appropriations Act overlapped with the provisions in the final transparency requirements. And as a result, the regulators provided helpful guidance describing which provisions would go into effect, which provisions would be delayed, and how the regulators were going to reconcile these varying provisions. So I'm only going to talk about the provisions that are going into effect, now or very soon. So the first one is prohibition on gag clauses. That went into effect immediately upon enactment of the Consolidated Appropriations Act and prohibits third-party administrators and insurers from including provisions in their service provider agreements that would prevent disclosure of their reimbursement rates, basically. And so you should ensure that if you're renewing your insurance contract or your third-party administration agreement, that you've reviewed it and eliminated any prohibition on receiving information relating to reimbursement rates. The next requirement I'm going to talk about is the prescription drug reporting, and you'll note on the chart that it's expected to be delayed. Well, just yesterday there was proposed regulations issued that said no, in fact it's going into effect on December 27th, 2021. However, the regulators are not going to, or they're putting in place a non-enforcement action, so they will not come after group health plans or plan sponsors or insurance companies who do not file reports by December 27th, 2021 or June 1st, 2022, but they will look for reports to be provided beginning June 1st, 2023. So look for more guidance on that. The next requirement I'm going to talk about is ID card disclosures. So this goes into effect beginning January 1st, 2022. So you should be discussing with your third-party administrators and insurance companies that they're going to reissue ID cards beginning January 1st, 2022. And they're required to include things like deductibles and out-of-pocket maximums and contact information if individuals have questions about where they can receive care or what the cost of their care is going to be. Provider directories also need to be updated effective January 1st, 2022. There are very specific requirements relating to what happens if a provider directory is not timely updated. And the long and the short of it is that participants are going to get the benefit of this. So if I call or if I review a provider directory that's available on the insurance company's website, for example, and it's out of date, but it says my OBGYN or whatever is an in-network provider, and it turns out that they're not an in-network provider, then I have to be, I pay the rate that I would have paid if they were in fact an in-network provider, and the plan has to pay basically the difference between what would have been paid as an in-network provider and what's paid as an out-of-network provider. Balance billing disclosure. There is a requirement that EOBs be updated to provide disclosure of in the event that an employee would be or a participant would be subject to balance billing. That goes into effect on January 1st, 2022. And again, you should be working with your insurance companies and third-party administrators to ensure that they're ready to do that. And the last requirement is this continuity of care requirement. And similar to the other requirements, it's intended to provide that if my provider is currently an in-network provider and they change to a non-network provider, then I'm going to get the benefit of that in-network provider billing, copay, whatever, for a transition period until I am advised that the provider is no longer an in-network provider and can transition my care to a new provider that's in-network should I choose, or if I choose to stay with my out-of-network provider, then I'm subject to the out-of-network billing requirements. Another item in the Consolidated Appropriations Act is this Mental Health Parity and Addiction Equity Act requirement. And for those of you who've attended our presentations in the past, you'll know that this is not a new requirement. And what the Consolidated Appropriations Act does instead is says that the Department of Labor now has a mandate to request non-quantitative treatment limitation analyses from group health plans. And they expect that you already have these non-quantitative treatment limitation analyses complete and at the ready. And so if they come knocking at your door, you generally have about 14 days to provide your non-quantitative treatment limitation analysis. Important to note that it does not apply to the Mental Health Parity and Addiction Equity Act does not apply to employers with 50 or fewer employees. So some of you can probably have a sigh of relief right now that you're not subject to this, but for anyone who has 50 or more employees, you should really be paying attention to this because this is a Department of Labor priority. If you are a fully insured plan, you should be talking to your insurance company about their non-quantitative treatment limitations analysis and how you would have access to it in the event that you are subject to an audit. If you're a fully insured, or I'm sorry, a self-insured plan, you should be asking your third-party administrator to identify if your plan differs from their fully insured book of business, and if it does, to identify for you how it differs, and if for the areas in which it overlaps with their fully insured book of business, you should be asking them for their analysis that you can have for your records. And where you don't, where you have differences, you should be performing your own analysis and asking for their assistance. The expected focus of the audits is prior authorization requirements for inpatient services, concurrent reviews requirements, standards for provider admissions to participate in a network and reimbursement rates, and out-of-network reimbursement rates. Okay, that ends the group health plans requirements, and I think I have about 15 minutes, so I'm going to talk quickly about retirement plans. And this is kind of a metaphor for my practice. Over the last 10 or 12 years or so, the practice or the focus of my practice has really turned to health and welfare plans, and the majority of the guidance that we see come out relates to health and welfare plans, and there's a lot of emphasis on health and welfare plans. But we can't forget we also provide, many of us provide retirement plans. So really quickly, if you have a 401k plan or a 403b plan, you need to have an amendment for the final hardship regulations, which were effective back in 2019, adopted by December 31st, 2021. And just to note that that is a hard deadline of December 31st, 2021. It does not relate to the plan year. So if you have a non-calendar year plan, the deadline is still December 31st, 2021. And on the right, you'll see that there's a requirement to amend your retirement plan if it has a hybrid feature or cash balance feature to include that the rate of interest is a market rate of return. There was an extended deadline for collectively bargained plans for to the last day of the 2021 plan year. So unlike the hardship regulations, which have to be amended by December 31st, 2021, this one, if this applies to you, can be adopted by the last day of the 2021 plan year. So if you have a non-calendar year plan, it may spill over a little bit into 2022. The Secure Act, which was enacted in December of 2019, would allow employers to adopt a non-elective safe harbor contribution at a minimum of 4% at any time before the end of the plan year. So if you don't know how your entity is going to perform or what your budget's going to be, but at the end of the year you find yourself with some money and you want to put that in your employee's plan, you can do that if you adopt by the last day of the plan year this 4% non-elective contribution. For 2021, because of the COVID-19 pandemic, there's a special rule that you can have a minimum 3% contribution if you adopt the amendment by 30 days before the end of the 2021 plan year. So for calendar year plan, you're going to have to act soon if that's something you want to take advantage of. Other safe harbor amendments generally cannot be adopted during the plan year. So if you're thinking about making changes to your safe harbor plan, think about making them now, or if you think you might be making changes in 2022, consider the exceptions that would apply to you. Moving on, 2021 was a big year for Department of Labor guidance with regard to retirement plans. Many employers reported having Department of Labor audits with regard to cybersecurity, and it was a little unclear what employers were supposed to do or what plan fiduciaries were supposed to do with regard to cybersecurity compliance, and whether the fiduciaries have an obligation to protect the plan assets and plan data of their participants once it's in the hands of a third-party administrator. And the Department of Labor provided guidance in April of 2021 that clarifies those questions. And the guidance came in 3 parts. The first is cybersecurity program best practices for service providers. tips for plan sponsors to hire service providers that have strong cybersecurity practices, and online security tips for plan participants. I'm going to skip over this slide that basically, if you get a Department of Labor audit on cybersecurity, this is what you can expect to see. So you should be probably looking at these things when you're interacting with your third-party administrator relating to cybersecurity practices and also your own cybersecurity practices. So what should plan sponsors do? I think first and foremost, you should be familiar with the guidance and you should evaluate what your current service provider is doing. Do they have strong cybersecurity practices, and does your agreement reflect the tips that the Department of Labor provided in the guidance for employer or fiduciaries hiring third-party administrators with strong cybersecurity practices? If not, you may want to consider doing an RFP. You're going to want to ask the new providers or even the incumbent, what are their best practices going to be going forward. You also want to communicate with your plan participants. Remember, the guidance includes tips for plan participants for cybersecurity. And there are quite a few tips, and they can easily be adapted for a communication that goes out to participants and also for your SPD. Many third-party administrators include multi-factor authentication as an option. If they have it, you should try to adopt it. And you're also going to want to evaluate the guarantees that providers provide for participants in the event of a cybersecurity theft. Not all protections are created equal. And if your third-party administrator is not providing great protection to your participants, you might want to try to get them to provide something better. The Department of Labor also issued missing participant guidance. This has been a priority for them, an audit priority for them going back probably 10 years. They are very concerned that with the kind of transient workforce, employees are missing out on their retirement benefits because we can't find them when benefits are due to them. So like the cybersecurity guidance, they issued basically 3 pieces of guidance. One is best practices for pension plans. The other is really a map that shows how they're going to investigate your plan with regard to missing participants. So it's kind of helps you identify things you should do to avoid having missing participants. And they also provided, temporary authorization for terminating defined contribution plans to use the PBGC's missing participants program. The red flags, the Department of Labor provided a red flags piece of guidance which says what they're looking for with regard to missing participants. So, if you have more than a small number of missing or non-responsive participants, they're looking for you to do something to find those people. Similarly, if you have more than a small number of terminated vested participants who are entitled to a benefit but have not started receiving their benefits, they want you to reach out and find those people. They don't like missing inaccurate or incomplete contact information, census information, missing social security numbers, birth dates, etc. in your data. They also want you to be following up on returned mail when you're sending mandatory notices or required notices. And they also want you to have policies and procedures in place with regard to uncashed checks and stale dated checks. I'm going to skip over a couple of these, but the bottom line is, similarly, you need to be familiar with the guidance and you need to be evaluating your service providers' processes and procedures with regard to missing participants. The DOL is going to view the third parties' policies and procedures as your policies and procedures, so you're going to want to know what they are and require that they make updates to them if they're not in accordance with the missing participant guidance. Looking ahead to 2022, it is now a requirement that defined contribution plans provide an annual lifetime income disclosure for defined contribution plans. So basically, they're going to look at what the participant's account balance is, today, and they're going to assume that you're married and that you're age 67 unless you're older, and they're going to actuarially provide you with a illustration of what your account balance would provide as in terms of a single life annuity or 100% joint and survivor annuity at age 67, or if you're older than that at the time they provide the notice at your actual age. Most importantly for you to know is that you need to start providing this notice if you have a participant-directed investments in your plan. You have to start providing the notice 12 months after September 19th, 2021, which would be either with the first or second quarterly statement. So plans that have participant-directed investments are required to provide quarterly statements to their participants. So you're going to want to include this lifetime income disclosure either with the first quarter quarterly statement of 2022 or the second quarter quarterly statement for 2022. If you do not have participant-directed investments in your account, then you have to provide the statement at the same time you provide the Form 5500 for the plan, for the first plan year beginning after September 19th, 2022. So it would be, if you extend your Form 5500 filing requirement, it would be October 15th, 2022. We also have amendments deadlines coming up. So mandatory as part of the Secure Act, you are required to change the required minimum distribution age from 70.5 to 72 for participants who turn 70.5 after December 31st, 2019. If you have automatic enrollment, automatic increase in your 401k plan or your 403b plan, you can increase the cap on your automatic increase from 10% to 15%. That is permissive. You could also add qualified birth or adoption distributions after December 31st, 2019, although I will note that many record keepers are not set up to do that. So you'll need to check with your record keeper. And lastly, if you have long service part-time employees, you need to be thinking about this. So effective in 2021, so already in effect, you need to be counting hours for these long service part-time employees. And if they're credited with more than 500 hours of service for 3 consecutive plan years, you have to allow them to participate in your plan as of January 1st, 2024. You only have to allow them to make pre-tax contributions to the plan. You do not have to provide them with any employer contributions. That one's a little bit tricky as well. And if you are having concerns about that, you should check with your third-party administrator, or obviously you can always contact Thompson Hine and we'll be happy to help you. CARES Act amendments. So you may recall the CARES Act was adopted in, I think, March of 2020, and it allowed plan sponsors to increase the amount of hardship distributions, basically, that participants could take in 2020 from whatever amount you had in your plan up to $100,000. It also allowed participants to take loans in a greater amount than would have otherwise been required or permitted from, we're not on camera, so you can come back here, from March 27th, 2020 till September 22nd, 2020. And you could also have stopped loan repayments from March 27th, 2020 to December 31st, 2020. Also, I skipped over at the very top, there was a permissive ability to waive receipt of minimum required distributions in 2020. So if you implemented any of these changes during 2020, you have until the end of the 2022 plan year to adopt them. I find it very helpful to be documenting now, or even previously, what you did in 2020, because I can't remember 2 years later what I did to make sure I get the amendment in my plan and the communications out to plan participants. And for anyone who has a defined benefit plan, you also could have had delayed funding obligations as a result of the CARES Act. And right on time, Alexis just joined us, and she is here to present benefits taxation. So thank you very much. And if you have any questions for me, I didn't see any questions pop up on the screen. I don't know if that's because I don't know how to work this or because nobody had a question. But if you have questions, feel free to email me. My information is on the website, and Monica can put you in touch if you need anything. Thank you very much for your attention this morning, and have a great day. So like I said, we're not on camera. We can get it to work, and filter goes that way. Thank you. Have a great day.
Good morning, everyone. So we'll go through a couple tax issues that have been kind of hot, especially this year due to, or the past couple of years, I guess now, due to the pandemic. Oh, and also I'm Alexis Kim. If anybody has questions, I'll try to catch them if they pop up. And if not, like Julia said, you can always reach out to us via email. So first, a brief background on fringe benefits. The IRS publication 15B is basically the Bible for fringe benefits. If you have any concerns, definitely look at that. They do update that resource annually at least, so it's usually pretty current. You know, the general rule, of course, is that all gross income includes all income from whatever source derived, which of course includes compensation for services, including your cash wages, but also fees, commissions, fringe benefits, and similar items. Because of the underlying employer-employee relationship, when you apply this general rule, it means that an employee's income could include both your cash salary or hourly wages, but also the value of any and all awards of property, goods, or services provided by the employer. And of course, there's various sections in the tax code that have granted exclusions from income for certain employer-provided fringe benefits if they meet the requirements. If the employer-provided fringe benefit is taxable, then the employer should include the value of the fringe benefit as income to the employee and must withhold and deposit the appropriate payroll taxes. So it's very important to make sure you're tracking these properly so you don't have withholding or failure to deposit penalties. Due to the pandemic, many employers have considered or are beginning to offer more fringe benefits to their employees to help facilitate them working remotely. Some of the fringe benefits may be provided to facilitate the work productivity, and many may also just be to boost morale. The IRS rules, however, on fringe benefits have generally not changed in response to COVID. So we're left to figure out how to apply the same old rules to what feels like a brand new workplace in many ways. The treatment of employer-paid moving expenses as well, I want to point out, was traditionally a non-taxable fringe benefit under Tax Code 132. However, that was suspended by the Tax Cuts and Jobs Act for 2018 through 2025. There's an exception for certain active military duty, but generally those are not excluded. Those are taxable to employees for a few more years. And then we've got here working condition fringe benefits. Those are the types of benefits for which the employee, if they had made the payment or purchased the item themselves, they would have been able to take a tax deduction for a business expense. So if they meet this definition, then the working condition fringe benefit is not taxable to the employee. Some common examples are employer-provided cell phones or a cell phone reimbursement plan. If an employer requires that the employee use a personal cell phone for business reasons, then that should be eligible for a cell phone reimbursement. So a recent example, we had a company that they don't actually even have landlines even in their offices. So whether you're working remotely or whether you are in the office, you're not given a business number or a business phone. So their cell phone reimbursement plan is considered a working condition fringe benefit. And there's some specific requirements for how the reimbursement is done, and that is addressed in the IRS publication. Also, employer-provided work equipment could be excludable as a working condition fringe benefit. So this is something that could definitely come up in the remote work environment. So if employees are working at home and the employer reimburses expenses for equipment that is necessary in order for the employee to perform his or her duties, or if the employer provides the employee computer or office equipment that is needed to work remotely, these would be non-taxable working condition fringe benefits. Now, de minimis fringe benefits are a different category. These are excludable under Section 132 of the tax code if they are provided infrequently and if it would be administratively impractical to track which employees receive the benefits or how much. For example, employer branded items like of low value, like swag, those are frequently non-taxable de minimis fringe benefits. Now, as far as the value, there really is no safe harbor from the IRS. They've issued a couple rulings, which of course are older, so you don't know for sure if the values you could take a reasonable position on increase due to inflation. However, the IRS has ruled that $100 in value is not de minimis. But on the other hand, it's issued guidance that $50 could be used as a reasonable rule of convenience. So you do see a lot of employers who say, okay, if it's infrequently provided and it's a value less than $50, it's a de minimis fringe benefit and not included in their income. De minimis fringe benefits can also include some snacks and meals provided to employees, again, on an infrequent basis. For example, snacks that are made generally available to employees in an open snack area or kitchen are usually de minimis fringe benefits. And that's true. There's been, in 2019, there was an IRS private letter ruling that addressed this issue. And they said even if the value of the snacks is fairly substantial, because you have no way of knowing how many an employee consumes on a given day, or what value, that it's not practical to be able to track that. So those are de minimis fringe benefits. Now, of course, we're not in an office where we can just put out snacks for employees. So employers might be considering a meal delivery service, or having a box of treats delivered to an employee's home. That could be different because the employer does have records of how much it paid for the meals for each employee. And if these types of meals or snacks are provided frequently, it's probably taxable income to the employees. Another thing that employers might consider in the remote work environment is, hey, you're working at home, you can't go, you don't have time to cook, we'll give restaurant gift cards, you can order takeout. Unfortunately, restaurant gift cards are a classic. They're a cash equivalent in the IRS's view, so they are always taxable income. There is also a separate section of the tax code, 119, that deals with meals provided for the convenience of the employer, and those can be excluded from income, even if they're provided frequently. However, the employer must have a substantial non-compensatory business reason for providing the meal, and needs to demonstrate that it would be impossible or nearly impossible for the employee to leave the work premises to obtain a meal, or to get a meal within a reasonable meal period. So an example of when that rule might apply is if there are emergencies that the employee needs to attend to, and they need to be available throughout their meal period, and so they are not able to go and get a meal outside of work. So that, unfortunately, again, is not probably something that applies in a remote work situation. However, as you have employees starting to come back to the office, there may be certain employees that you can show a substantial non-compensatory business reason why they need to be available during their meal period. All right, so that's it for fringe benefits. The next topic I've got here is remote work tax issues. And this has been a significant issue both locally in Ohio as well as just nationwide when you think of multi-state issues. So I'm going to focus primarily on the employee municipal income tax withholding regime here in Ohio. Not all states do have a decentralized local tax regime like Ohio does. But here, home rule gives each municipality, each city, the authority to administer its own tax regime. And so this system has left many employers confused with the newly remote workforce or maybe partially remote workforce. So the general rule in Ohio is that an employer must withhold municipal income tax based on where the employee performs his or her work. If an employee works in a given municipality for more than 20 days per year and the employer is considered to be doing business in the municipality, then the employer is required to withhold to that municipality. Before COVID, this meant that most employees who were in an office on a daily basis were assigned to that office as their principal place of work, and the employer would withhold municipal income tax based on the city where the office was located. And an employer could, as an accommodation, also withhold to the employee's city of residence, but that was not mandatory. The employee could then get a full or partial credit, depending on the rules in their city of residence, against the tax liability. The system wasn't perfect, but it was well understood under the traditional workplace where employees went to the office 5 days per week. And of course, when many employees suddenly were forced to work from home beginning in March of 2020, employers scrambled to figure out what their withholding responsibilities were. So initially, Ohio House Bill 197 was passed very early in the pandemic, and that included a temporary rule that permits employers to withhold based on the city where the employee is assigned. So that would be their pre-COVID office location, the principal place of work, so long as the employee is working at home due to COVID. So the requirement is you're working remote only because of COVID, and then the employer continues to withhold based on the office location. And then, of course, the budget bill that was passed this year extended that, what they call the deemed principal place of work withholding rule, through the end of 2021. So your current work policies that are in place should demonstrate that the employees who are continuing to work from home are doing so because of the COVID emergency. And if that's the case, then the employer can continue to withhold based on the principal, their former pre-COVID principal place of work. So things that you would need in the policy to have to state that the policy, the continued remote work policy, is based on the need to reduce the risk of spread of COVID. And then postpone any long-term, if you're considering doing a full-time or hybrid or remote option for your employees, postpone finalizing that and making it a permanent policy until 2022, just so that through the end of now, I mean, we're already in November, but for the next month and a half, you can continue to withhold based on the principal place of work. And then your employees are permitted to request refunds for the municipal taxes that were withheld to the office location if they were not working in that city during 2021. The employer will be asked to certify how many days the employee worked in the office. You don't have to certify as to how many days they may have worked or where they worked the other days. You just have to certify that they worked X number of days during 2021 in this city where the office is that you withheld. As for 2020, the tax administrators, RITA and CCA, are holding any employee refund requests due to some ongoing litigation, and the budget bill that included the provision that allowed employees to get refunds for 2021 did not address 2020. So moving forward, we have not had any additional extensions. There was some legislation proposed earlier this fall to streamline the withholding for employers, but it does not appear to be going anywhere. So beginning in January, the employer will be required to follow the general municipal withholding rule, which mandates the employer withhold to the city where the employee is performing the work. Of course, subject to the 20-day rule and that the employer is considered to be doing business in the city where the work is done. So the employees who are working at home, if they live in a different city than where the office is, and if they're working at home at least 20 days per year, the employer will be required to withhold in the city of residence. So for 2022, you'll want to consider if certain employees are going to be working remotely full-time, it may be appropriate then to assign them to a new principal place of work and have them be assigned, whether that's to their residence or to another location, but not the office, and just consider them as full-time out of office, full-time work from home. And then you only have to withhold on the city of residence. If you have a hybrid policy where employees are working partly in office and partly remote, then you will need to think about how to set up a process to track the number of days that are worked in the office and the number of days worked at home. And so that could be something just when they log on to their computer, a question, a box pops up, or you could have something if you have hourly employees, when they clock in and clock out, that it tracks that. And you'll need to consider whether merely having a single employee who works at home in a municipality is sufficient to cause you as the employer to have the strong connection to or nexus to that municipality where the employee resides. If you simply do have only one employee working at home in one municipality, you may, and you aren't doing any other business activities in that city where they reside, you may be able to take a reasonable position that that you are not doing business in that city, and therefore the withholding regime does not apply. However, the employee will still be required to pay the tax to their city of residence, and that could be burdensome to them because at the end of the year, they'll have a big tax bill, they'll have penalties if they didn't make quarterly estimates. So for the sake of your employees, it's a complicated system for the employer to have to withhold to multiple cities. However, it could be beneficial and make things easier for the employees. And then the last piece on remote workers is also keep in mind if you have any employees who are working outside of Ohio. People think, hey, I can do my job from anywhere, even from a beach in Florida, right? So if you do have employees working remotely, there's reciprocity agreements existing in place that have been around for decades between Ohio and the states immediately adjacent to us. So Pennsylvania, West Virginia, Indiana, Kentucky, and Michigan. For those states, the rule is usually that you only have to withhold in the state of the residence, of where the employee resides, and that applies whether they're working at home or working in the office. If they're going on vacation in Florida, though, that could be a different story, because we don't have reciprocity agreements in place with most other states. If it's just a vacation and they're not working very many days, then it's likely that that they wouldn't have any withholding required. But if an employee's, flying out somewhere and staying for a couple months, doing like a snowbird thing, but working remotely while they're there, then that could create a withholding requirement. Every state differs what their rules are and whether they give credit for other state withholding. So if you do encounter employees who are considering doing this for long extended periods of time, definitely you could reach out to us or reach out to if you have a reliable accounting firm that takes care of your state and local tax. Yeah, and I have a minute here for questions if anybody has them, but I don't see anything popping up. Yeah, feel free to email me if you think of anything else. Alexis Kim, and I'm on the Thompson Hine website, of course. And then I believe we've got a 10-minute break, and then Nancy will join us, or sorry, no, I think Hannah will join us next, and she will discuss some additional, and then Nancy Barnes will be in later. All right, thank you.
Hi, everybody. I don't know if you're back from the break. We are going to get started in a second. I apologize. This is Nancy Barnes, by the way. Good morning, everybody. We were having trouble with our chat box, but now we've been able to open the questions. Alexis is still here. There was a question for her, and so she stayed on to answer that question, and then we'll get started with my presentation. So Alexis, do you want to share the question?
Yeah, thanks, Nancy. So the question is, if, for an example, someone is working 2/5 in the office in Cleveland, 3/5 at home in Lakewood, are we then withholding 2/5 in Cleveland, 3/5 in Lakewood for the year, or two days per week in Cleveland, 3 days per week in Lakewood? So yeah, moving forward, starting in 2022, that will be the withholding regime under the general Ohio rule. So if they're working in the office in Cleveland 2 days a week, you withhold based on 2 days a week, and then 3 days in Lakewood. And of course, those are two municipalities. We didn't really, that do have income tax. Of course, there could be some employees who live in like a township that doesn't have municipal tax, and then they really get they would only have to withhold the 2 days that they're in Cleveland.
And Alexa, I have a question. I'm just curious.
Yeah.
If someone doesn't have a set schedule, so they're sort of, this week they were in 1 day a week, next week they're in 4 days a week, is there some rule of thumb, or do you have to go back and actually do an analysis of they spent 50% of their time in one location or the other?
Yeah, unfortunately, you're really actually going to need to track day by day. So I'd suggested having something that pops up on your computer when you log in, or if you have hourly employees, when they like sign in and sign out, to say, I'm working in the office today, or I'm working at home today. It's a burdensome system for employers, but unfortunately, the Ohio legislator didn't pull through with any new rules.
Okay, awesome. Well, great. Well, thanks for that question.
Yeah.
Thanks, Alexis. Really appreciate your time. Okay, so we are going to go ahead and get started on the employment law update for this year. Very little to talk about. I wish. It has been it's been a challenge for all of us who have to deal with these issues, which in many cases are novel issues that none of us have ever had to deal with before. But I did want to spend some time today talking with you about some things that have happened in the courts, things that may have some sort of practical impact on issues that you are dealing with. make sure you're aware of some developments, particularly here in Ohio. And then we'll do some of our favorite things, doing some hypotheticals and quiz questions to see, test your knowledge on the application of some of these things. And then unfortunately, we are going to talk about some COVID related stuff. I honestly am so sick of talking about COVID. I was hoping to do some presentations here at the end of the year where we talked about other stuff. But OSHA decided that that wasn't going to be possible. So I do feel compelled to talk with you, even though some of you are not probably covered by the OSHA ETS, to talk about some of the issues that that raises, even for those of us who are not covered. So the first thing I want to talk about is just kind of bring you up to speed on some significant cases that have been decided over the past couple of years. I did include a case from 2020 because we didn't do this last year. So this is just sort of a remedial reminder about some things that happened over the past couple of years. You may recall that the U.S. Supreme Court last year, this was one of the last decisions they issued in their 2020 term, was a case called Bostic versus Clayton County. And it was a case dealing with Title VII and whether it applied to employees who claimed that they were discriminated against based on the fact that they were gay, using Judge Gorsuch's terminology, or transgender. And in a 6-3 decision, and frankly nowadays, like, that's kind of surprising that it was a 6-3 decision, the court held that discrimination on the basis of either sexual orientation or gender identity, it falls within the because of sex prohibition included in Title VII. And so it was somewhat based on sexual stereotyping, which you may remember from the Price Waterhouse case that was decided, I think, back in 1989, dealing with a workplace where, women or men were supposed to act in certain ways pursuant to gender stereotypes. And so applying that to the issue of sexual orientation or transgender, it sort of brings that in within the fold of Title VII, because certain conduct of, for example, a woman being attracted to a woman doesn't meet sort of traditional stereotypes for someone who identifies as being a woman. And so therefore, that is one of the bases for this being covered by Title VII. So lots of cases have dealt with these issues since that decision was issued, but just wanted to bring a few to your attention. So there was a case in October of last year dealing with benefits related issues. A plan was not allowing a female employee to enroll her female spouse in the plan. That was held to be discriminatory under Title VII. In the case of Doe versus Triangle Donuts, this is the case out of Pennsylvania from last year. I wanted to bring this to your attention because this was a transgender case. And, sometimes you read a little paragraph about a case and it talks about the fact that the intentional use of pronouns or using someone's name for this individual who previously identified as male, that was a violation of Title VII. And then when you read the actual, the case summarizing sort of the allegations and the issues here, this was not a case, and I frankly haven't seen cases coming out yet where it's an oh, oops sort of situation. So, somebody who previously worked in the workplace and used a male name, and somebody, they've changed that as of Monday. They used to use the male name on Friday. Somebody by mistake calls them by their male name or uses he. I haven't seen cases coming out with that sort of, oh, oops, I keep forgetting, sort of unintentional behavior. This was a case where it was nonstop harassment of this individual by both managers, coworkers, customers. They had rules in place that this individual who identified as female and wanted to wear makeup and nail polish, there were specific rules that this employee could not do that, even though female employees could do that. So, I mean, this was really egregious, disparate treatment of this individual. But there's certainly, you know, there's plenty of those cases, and now we have Supreme Court precedent that says, you know, that type of behavior, discrimination, harassment, et cetera, based either on sexual orientation or transgender status or gender identity is covered by Title VII. And of course, that filters down to state laws that have similar prohibitions that follow sort of federal interpretations of Title VII. So that would be true, presumably also under the Ohio Civil Rights Act 4112 follows Title VII precedents. The third case that I wanted to bring to your attention was this Meriwether-Hardtop case versus Hardtop case out of the Sixth Circuit, which is the circuit governing Ohio. And in this case, this was a professor down at Shawnee State in Southern Ohio who said that he had a religious objection to following the university's policy, which required professors to address students by the pronoun of their choice. And because this professor refused to do that, the student brought a Title IX claim, which is an education-based discrimination claim within the university system because the professor was not following this policy. And this is one of those cases where when you have, and we're going to be talking a little bit about religious accommodations, probably all of you are thinking more about that than you ever have in the years of your career. But when you're talking about religious accommodations, one of the things I've noticed in some cases is, I think one of the things, and I'm not saying it changes the decision of the court, but I do see a common thread here. The university was very dismissive of this professor's religious beliefs about whether or not he could follow this policy and whether there could be an accommodation of his religious beliefs about the God-given sexual identity of individuals being provided at birth. And I think that that does filter into sometimes the court's decision because the university was so dismissive of it. Didn't take it into account, didn't consider it, didn't look into, is there some way? The professor had offered some options for how he could, he thought, comply with the policy, but not do things that were counter to his religious beliefs. And they wouldn't even consider them or say why it was that that wasn't something that they could accommodate, et cetera. So I think that may have influenced the outcome of the case. But in any case, this was, of course, a state entity. And so the professor had argued that this was a violation of his First Amendment rights, which obviously apply with a public institution. And so therefore, in this case, the Sixth Circuit said that he could not be fired for failing to follow this policy because of his religious objection. So another case out of the Sixth Circuit that I wanted to talk with you about a little bit, and we have a little quiz question, is a case that involved the city of Cleveland. In this case, the court was being asked by a group of plaintiffs who had brought a claim because the city had decided that when they were assigning EMTs shifts, they wanted to assign some white EMTs to certain shifts to diversify the team so that they would not be all Black employees on particular shifts. And so the EMTs sued, saying that this was race discrimination. The city countered by saying the decision did not have an adverse economic impact on the plaintiffs, and they said it was part of their diversity plan. So who do you think was right in this case? Do you think it was the plaintiffs because any change in working conditions is sufficient to support a discrimination claim? Do you think it's B, the plaintiffs, provided that they can show that there was an economic consequence? Do you think it's C, because the plaintiffs, it should be the plaintiffs if they can show other impacts like reduced seniority benefits or fewer supervisory responsibilities? Or D, do you think the city was the one that was right because as long as it can show it took the actions to promote its diversity objectives? Now, if we were here in person, and I do miss seeing all of your smiling faces and doing the quiz questions, we would have our little clickers and vote away. We did not, because of time constraints, use the technology that's available. If we ever have to do this again virtually, I promise I will give you the quiz questions and let you vote. But anyway, let's shout out to those who got this right mentally. The correct answer is C. And why is that? So let's start with A. Any change in working conditions being sufficient to support a claim. I mean, honestly, for those of you who deal with discrimination claims or charges or issues, you do not want that to be the right answer, because that would mean, oh, you know, you changed the carpet in my office and I don't like the color. It used to be dark and now it's light and I don't like that. And I think you did that because I'm old, I'm a woman, I'm pregnant, I'm whatever. You would not want any change in working conditions to be sufficient. So, so A is not the right answer, thankfully. B is also not the right answer. And this is something the Supreme Court ruled on quite some time ago, saying that it's not just about changing something that, you know, changes somebody's rate of pay or their bonus or their raise. It changes in terms and working conditions means more than that, but it has to be a material change, which is why C is the correct answer. If it has an impact on somebody's seniority benefits, their opportunities for development, things like that, then that's going to be a material change. And that's what was going on in this case, because you bid on shifts by seniority. And so if the city was allowed to say, like, well, we don't care that those of you with more seniority are bidding on presumably the more favorable shifts because we want to make a decision based solely on race, then that is something that's going to be a violation of Title VII. And so the diversity objectives, particularly because race, there's a higher standard for making decisions that are based on race. Those diversity objectives are not going to sort of give the city carte blanche there. So again, this is just a quick description of this case, how it was brought. And the interesting thing is Judge Gwynn, who's here in Cleveland, he ruled on summary judgment that the decision was based on race. So there was no question about that element, but what he said was it's not a material adverse employment action, which the Sixth Circuit disagreed with because of these supervisory responsibilities as well as the seniority. And the Sixth Circuit obviously rejected the idea that you have to show economic harm. That is not an element of such a claim. Okay. Another case that might be interesting to you is this case out of the Sixth Circuit decided this year dealing with retaliation. I will tell you, I didn't include the EEOC statistics for last year because I had so many other things I wanted to cover with you guys. But just as an aside, the EEOC published its statistics with charges that were filed in 2020, which there were a lot in fiscal year 2020, a lot fewer charges. I would say COVID was a contributing factor to that. But as this has been the case for years and years and years, most popular claim is retaliation. 55% of charges filed include a retaliation claim. It may not be the only claim, but it is one of the claims. And as I've told you many, many times, those of you who talk to me about these issues, oftentimes, you know, it's not the crime, it's the cover-up. It's not the original complaint that's the problem. Somebody says, you know, I think my boss is discriminating against me based on, you know, age, sex, gender identity, whatever. You look into it, you investigate it, you have a remedy, you discipline, you do whatever you're going to do, and then it's the after effects that actually get you into trouble because of retaliation. So in this particular case, one of the things the court was dealing with was retaliation claims, the opposition clause and the participation clause. So there's two different ways that retaliation claims can arise under Title VII. One is if somebody is opposing discrimination. So they're saying, you know, I think this policy is discriminatory. I think my boss is discriminating against me. I think my coworker is harassing me based on fill in your protected category. That is an opposition type of action that's protected and for someone to be retaliated against because they were opposing discrimination is a violation of Title VII. There can also be retaliation claims that arise from participation. So I was a witness to some meeting that somebody says, you know, there was harassment going on or something inappropriate was said or whatever. I'm called in to share whatever it is I know about that meeting. I'm participating in an investigation. If I were to be retaliated against for participating, that is also protected activity under Title VII. Well, in this case, the claim was brought by an HR director who had received numerous employee complaints about a particular individual, had done an investigation, had come to some conclusions that I don't think were very well received by her superiors. And so she then brought a claim because she felt that she was being retaliated against because of raising these issues that have been brought to her by another employee. And one of the questions that the court had to deal with is, okay, wait a second, is this protected activity for this HR director whose job it is to do this sort of thing? Is that protected activity that falls within Title VII? And the answer to the question pursuant to the Sixth Circuit is the answer is yes. So again, it's not really surprising. That seems like the way it should come out, but now we have Sixth Circuit precedent saying that is the case. Some other things that they addressed in that opinion, we're talking about complaints and how they're expressed. They do have to be expressed in a reasonable manner. So if you have somebody who is creating all kinds of issues within the workplace and kind of not following sort of quote unquote normal channels where things have been addressed previously, and they're creating morale issues, et cetera, after a complaint has been addressed and things have been discussed, et cetera, that can be an issue where maybe that person can be subjected to some type of coaching or discipline. Again, somebody has to have a reasonable good faith belief that the opposed practices are unlawful. We all know that. And what is a good faith belief? Is it something where, they know their boss is getting ready to discipline them, so they throw this out there to try to insulate themselves? That's probably not good faith. It doesn't mean that they have to be right. They may be wrong. They may have no one else who witnessed it. That doesn't mean it's not a good faith belief. Protected activity includes complaining to anyone. So just to be clear, they don't have to complain to a specific person in order to have their activity protected. So it doesn't mean like, well, you didn't complain to HR, so sorry, that's not protected. That's not the standard. If they are complaining to their boss, their supervisor, to HR, to the executive director, that's going to be protected activity. Another important case out of the Sixth Circuit this year was this Pelcha versus MW Bancorp. This dealt with the ADEA, which is the Age Discrimination in Employment Act, which has a different standard of proof. It's called the but-for standard, which is a higher standard of proof for an age discrimination claim. You have to show that age was the but-for, meaning it was the reason, not one of many reasons, but the reason for whatever happened. The person was terminated, wasn't hired, whatever the adverse employment action was. In this case, there was pretty good uncontested evidence regarding the individual's insubordination and their sort of having an attitude with their supervisor and refusing to follow a policy. So there was a lot of evidence about the insubordination of the individual, but there was also evidence, unfortunately, about comments that have been made by the CEO, talking about his desire to hire younger employees, talking about how older employees had sort of stayed on past their quote unquote shelf life. These are exact quotes. So that created problems. And oftentimes, that's the sort of situation where it's very difficult to get out of a case like that without either going to trial or settling it. But in this case, the court was addressing what was the standard of proof. And what it said was, it's in the Sixth Circuit, and there's some cases out there that are different in other circuits, talks about, yes, for age discrimination, the standard is still, it is a but for, that has to be the reason for sort of that adverse employment action. All right, so that was a quick review of some, pertinent federal decisions. For those of you who aren't lawyers or were like, wow, that was really boring, we'll try to cover some things that maybe are a little more interesting for you in this next section. We're going to talk a little bit about some things in Ohio. The one thing that you should be aware of, and this kind of is surprising to me, it kind of went under the radar until right before this thing went into effect. The Employment Law Uniformity Act, ELUA, was a statute that went into effect April 12th, 2021. If you're somebody like me, I watch the docket every day. The number of cases that were filed in the first 2 weeks of April against employers was like astounding. It was like pages and pages long because this change was going into effect, and the plaintiffs' attorneys in town wanted to make sure that they got their claims filed before this thing went into effect. So what did it change? First of all, it requires employees to file a charge with the OCRC before they can file suit. So if you terminate somebody today, and they say, I'm going to sue you for fill in the blank, race, age, religion, gender, whatever, they're not going to be able to file a complaint in court tomorrow. They are going to have to go through the charge process, either through the EEOC or the OCRC, which is the Ohio Civil Rights Commission, before they can get their right to sue letter and bring a claim against you. Now, one of the things that happened in the old days, before April 12th, you used to have 180 days to file a charge. Now they have 2 years to file a charge with the OCRC. The big news and thing that people were really, really happy about is this largely eliminates supervisor liability unless that person acted outside the scope of employment. So it was pretty common practice for claims that were filed in the state courts of Ohio. Title VII does not allow for individual liability. If you are filing a claim under state law in Ohio, it was very, very common to at least include a supervisor or manager for a number of different reasons. Number one, create some leverage. That individual is now named as a defendant. They have to get counsel. It gives sort of ease with respect to discovery of that individual's personal information, stuff on their personal phone, personal computer, personal financial assets, much more discovery than would be the case if they were not an actual party to the case. Unfortunately, sometimes the list of people who were identified as individual defendants would include, for example, HR people. I complained to, ABC, Susie Smith, who was the HR director about this, and she didn't do anything. So I'm naming her in the complaint too. Or, so-and-so was the executive director. They weren't my boss, but they made the ultimate decision to terminate my employment. So I'm naming them in addition to my boss who was harassing me or whatever. So there would be a lot of people who potentially could be defendants. So that's now largely eliminated, except for when people act outside the scope of employment. And what's kind of interesting here to see, how this plays out is if someone was acting outside the scope of their employment, it's not clear to me how the then employer is responsible for that. So, typically, plaintiffs, attorneys, and plaintiffs, what they're really interested in is who has the biggest checkbook. And typically that's the employer. So if they sue the manager or supervisor and they say the person was acting outside the scope of their employment whenever they did whatever horrible thing they did, that potentially could create a situation where they only have a claim left against the supervisor and they're not able to bring a claim against the employer. So that's going to be interesting. I think plaintiffs' attorneys are smart enough to focus on who can actually pay out their claim. So we'll see what happens with that. The other big thing is the statute of limitations, which was super confusing in Ohio under different provisions. It could be different things, and depending on how you filed or what subsection you filed under, there were different rules. Now it's all aligned. It's been reduced from, it should be shortened. Sorry, not shorted. I look like I'm selling stocks. It's now shortened from 6 years to 2 years. So that's good news. Another development in Ohio, these are our bills that are currently pending. It'll be interesting to see if one or both of these actually gets passed and signed into law. House Bill 401 is dealing with workers' comp coverage for injuries that might result to an employee because their employer is requiring them to be vaccinated. It would create a new cause of action, sort of independent and outside sort of the workers' comp process. And then House Bill 435 says that there's express coverage under the Workers' Comp Act for injuries or disabilities that are caused by the mandated COVID-19 vaccine if an employer mandates. So sort of, two completely opposite approaches. I don't know if one or both or either will pass, but they're sitting out there and people are thinking about those issues. Okay, religious accommodations. This has become probably my favorite subject of the year. I literally have been practicing for 27 years. Religious accommodations, I've probably pre-COVID dealt with maybe 3 times in my career. And this week I've dealt with it more than 3 times. So it's kind of crazy. I'm sure many of you have had to deal with these issues. But I wanted to start by talking a little bit about some cases that were decided before religious accommodation became fashionable due to COVID. So, but these are interesting because they suggest that if these issues come before the Supreme Court, we may get an unusual result or an unexpected result. So if you look at the first case, EEOC versus Walmart, and for those of you who've been with my presentations previously, oftentimes we have a Walmart case as one of our update cases, and almost always Walmart loses. Well, guess what? They won this time. This is a case out of the 7th Circuit, and this was a case where they had a manager who was asking to be off on Friday nights and Saturdays. I think he was a Jehovah's Witness. And so he had applied for this assistant manager position, and Walmart said, yeah, we can't accommodate that. Weekends are really busy. We need our other we need managers here on site. It's unfair to the other managers for you to always have basically, we'll call it Saturday off. And creating an accommodation would be more than a slight burden. So for those of you who talk to me about ADA type accommodations, you are probably familiar with the fact that the accommodation provision under the ADA is not, does this cause a slight burden? That's not the question we ask. You call me and say, listen, Nancy, if I give this accommodation to this employee, I'm going to have morale issues. This other person's going to have to pick up the slack or do this because that person's in the office and this person's working at home, and it's going to create these issues. And I say to you, gosh, I'm so sorry to hear that. That doesn't change anything. You still have to provide that accommodation under the ADA. When you're talking religious accommodation, the standard is much lower. And this is Supreme Court standard, slight burden. So that was the EEOC case. Same thing, same principle in Small versus Memphis Power. This is a 6th Circuit case. That's our circuit. This is an employee who ultimately was terminated because he did not show up at work to attend a Good Friday service. He had other absentee issues related to his religious observance. This was obviously a power company that needed to have crews out on sort of an emergency basis. It wasn't something where they always could have everything scheduled, and this was a function of this job, and they said they simply could not, accommodate this regular sort of religious observance and not being available for certain shifts. And the court said, yep, that is, you've said you have more than a slight burden. You cannot accommodate this religious accommodation request. Same thing in Dalbertista. I don't know if I'm saying that correctly, out of the 11th Circuit. That's down in like Florida, Georgia, etc. Same thing, an employee who could not work on the Sabbath. The employer showed that that created more than a slight burden, and the court said, okay, you don't have to accommodate based on religion. Now, let me go back to this for 1 second. When these cases went, I think they all went up on a petition for cert to the U.S. Supreme Court to say, hey, U.S. Supreme Court, we'd like you to hear this case. those petitions were rejected, and there have to be 4 justices who will say, yeah, you know what, I think we ought to listen to this case and see what we want to do. But there were 3 justices who wrote opinions, Alito, Gorsuch, and Thomas, joined in various opinions saying, we want to revisit this. We know this standard has been in place, I think, since 1977 for like a slight burden, but we think that this is unfair because people who are requesting religious accommodations are not being treated sort of the same way that disability-related accommodations are treated. We want to revisit this. Okay, so these all went up on cert before we had the current composition of the Supreme Court. So what would happen today when I'm assuming these religious accommodation cases related to COVID go up? It's going to be interesting to see if the court will take those on and potentially change the standard that's been in place for like close to 40 years. Okay, I can't do my math, 35 years. Anyway, mandatory vaccination. This is something that lots of people have questions about. Just wanted to share this case with you out of the Eastern District of Kentucky, which is here in the 6th Circuit. This court was dealing with an employer's, I mean, this is like an employer who just decided, has nothing to do with OSHA, ETS, et cetera. This employer decided we are going to have a mandatory vaccination policy, and the employees had to either get vaccinated or have a religious or medical accommodation. And if they didn't, then they were going to be terminated. And, the plaintiffs argued, I'm sure many of you have heard these arguments, that this infringed on their constitutional rights. They didn't, obviously they were not covered by the ADA or religious exemption. And the court concluded that the plaintiffs who were bringing these constitutional claims had 0 likelihood of success on the merits. Now, I will tell you, that's not the standard that the court had to find in this case. It was on a preliminary injunction. And in those types of cases, what a court is trying to decide is, does the person who's bringing the claim have a reasonable chance, or do they have a probability of succeeding on the merits? In this case, the court was like, there is 0 chance of success on the merits on those constitutional claims. And partly that's because the employer was a private hospital and not a state actor. So that was obviously weighed into the issues. But the court went on to discuss, some of these other claims that same sorts of arguments that are being made with respect to the OSHA ETS standard, which we are going to talk about, made some of those same arguments, and the court pointed to a Supreme Court case that you may have heard about, that frankly nobody's been talking about for 100+ years, but now they are, decided in 1905, where there was a state imposed, so government actor, but a state, not federal government, requiring smallpox vaccination. And if you didn't get the vaccination, you were imprisoned. And that was upheld by the US Supreme Court 15 years ago. The court said that this mandatory vaccination policy was well within the confines, it appropriately balanced public interests. And then it has this quote here, which I'm sure is going to show up in a lot of briefs on these types of issues. But the court said that if an employee believes his or her individual liberties are more important than legally permissible conditions on his or her employment, i.e. vaccination or maybe now testing, that employee can and should exercise another individual liberty, no less significant, the right to seek other employment. So I'm sure that we're going to be seeing that quote in a lot of places moving forward. So that brings us to the OSHA ETS. This is my favorite thing to talk about over the past couple of weeks. So first, I just want to talk very quickly. I think most people on the call probably are not covered, but just in case you are, or if you don't know if you are, let's just talk about this really quickly. OSHA ETS applies to what OSHA calls a large employer. So if you have 100 or more employees, then, and we're going to get to the litigation in a second, but let's assume this goes into effect, then you have to require your employees to be vaccinated, or as an alternative, you can allow your unvaccinated employees to test weekly and they must wear masks in the workplace. Okay, so a lot of people, this is like my little pet peeve, a lot of people call this, mandatory vax policy, OSHA's mandatory vax. It's not a mandatory vax. No employee under this standard has to be vaccinated. No one under the standard has to be vaccinated. If everybody's unvaccinated, then there's just rules that apply to the people who are unvaccinated. So it's really not a imposition by the federal government of mandatory vaccination. Does OSHA, does the federal government want everybody to be vaccinated? Unquestionably, yes. If you look at the objectives, they make it as clear can be what they are trying to achieve here. And what they're doing with respect to employers is they're saying to employers, listen, the easiest thing for you to do is to tell your employees they have to be vaccinated. That's the easiest thing to do. Now, they don't care about the fallout. They don't care that you can't recruit people right now. And if you have a mandatory vax policy, it's going to make it harder. Like, that's not their concern. Their concern is they want as many people as possible vaccinated. So that's the objective. Now, pre-litigation, and again, I'm going to talk about the litigation in a minute. This went into effect November 5th, 2021, so a couple Fridays ago. Most of the provisions in the ETS are subject to enforcement December 6th, which they moved the date because now that's a Monday, with enforcement of the whole thing, including the testing and vaccination, which is what people are probably most worried about, effective January 4th, 2022. Now, OSHA had a press conference or a press release yesterday and saying they're not going to enforce right now. And some people said, okay, great. I'm going to kick back. Sorry. I'm going to kick back. I don't need to worry about this anymore. OSHA's not enforcing. Well, I mean, OSHA did not make a promise that it's not enforcing for the, duration of this ETS. It hasn't said that. And it hasn't even said it's not going to enforce, pursuant to certain conditions related to the litigation. It just said it's not enforcing right now. It could issue a press release tomorrow and saying, you know what, we've changed our mind. We are going to enforce unless we legally cannot do so pursuant to a nationwide injunction. So we're going to talk about all that in a second. It is in effect for 6 months until May 4th. For those of you who are thinking about if you're covered by this, we may be required to do testing. How much is that going to cost? Are we going to pay for the testing? All that kind of stuff. Be aware, some people were pricing that as 6 months from January. Your testing obligation would end on May 4th. So it's really 4 months of the testing, if that makes anybody feel better. So, okay, we'll do a little quiz question before we get into the litigation. Julie is head of HR at ABC Company. Her CEO has been reading about the ETS and wants to be certain that they are not covered. Julie pulls information from the HRIS system and finds that the company has 50 full-time employees, 40 part-time employees, and 20 workers who are temps that are placed there by a staffing agency. ABC also has plans to hire 20 workers for the holiday season, but they're going to be terminated by December 31st. Julie tells the CEO that ABC does not have to worry about the ETS because it doesn't become fully effective until January 4th, 2022. Is she right? Okay, so this is about how you count your employees. A, she's right, yes. ABC will not have over 100 employees on January 4th and therefore doesn't have to comply. B, yes, ABC doesn't have to include the temporary employees, meaning both the staffing agency employees and the seasonal employees. C, yes, she's right. ABC only has 90 employees, full-time and part-time, at least on the day that the ETS went into effect on November 5th. Or D, no, ABC is covered. So I tried to make the math easy. Even I can do the math, so I figured we can all do the math here. Do we think Julie is right or is she wrong about whether or not ABC is covered? Well, it turns out the correct answer is D, ABC is covered. Why is that the case? Let's go through the wrong answers. It does not matter how many employees you have on January 4th. That is not the question for purposes of whether or not you are covered by the ETS. The ETS measures coverage from the moment it went into effect, which is November 5th, and for the entire period it is in effect. So what that means is if you plotted out your number of employees. If that number ever hits 100 for even, 1 hour, you are then covered by the ETS from that point going forward until it expires. Okay, so A is incorrect. B is incorrect because you do have to include your seasonal employees. If they are your employees, even if they're only your employee for a week, even if you hired somebody and you terminated them the next day, they are your employees and must be counted. Full-time, part-time, seasonal, everybody's an employee, you have to count them. If they are employed by somebody else, a staffing agency, they are independent contractors, they do not have to be counted in your head count. Same thing is true for C. It's wrong also for the same reason that A is. It's true they only had 90 employees when it went into effect, but those seasonal employees are going to push them over the 100 threshold, and so they're going to end up being covered. So how to count employees? If you have multiple locations, you're not counting by location, it's your overall head count. If you have 2 or more related entities, it's a complicated analysis under OSHA, but let's go back to basic principles. OSHA wants you to be covered. So if you think it's a close call, well, maybe if we look at it this way or that way, but you sort of have policies that govern all of the employees, even though some of them are in a different LLC or something like that. OSHA's presumption is they're going to be covered if you're over the 100 threshold. So I would just assume you're covered, even if they're between 2 entities, unless there are really strong distinctions between 2 separate entities. Okay, the ETS litigation, everybody's favorite subject. Lots and lots of states banded together to immediately file lawsuits that were filed in every circuit except the 10th Circuit, which is out in Denver. And they have a million different theories for why the ETS should be not enforced or enjoined or held to be unconstitutional, et cetera. Interestingly, some labor unions filed in some other circuits in order to have cases pending in what they consider to be the more liberal circuits. And we'll talk about where it's pending now and what may happen. But in any case, there are lots of arguments out there for why the ETS may not be upheld. And it very well may not, because there's a very high standard for the issuance of an emergency standard, because it doesn't go through the normal process for a federal regulation. So first of all, one of their arguments is that the ETS does not address a grave danger, which is something that is a requirement for an emergency standard. Query whether, I don't know, 700,000 people dying is a grave danger or not. Not sure, but the numbers of deaths are going down. So how the court will interpret that, don't know. They're arguing that COVID is not a substance, agent, or hazard, which is part of sort of the OSHA jurisdiction. They're saying it's not necessary, which there are a bunch of tests about whether or not it's necessary. True, no process for public comment. That's typically true in an emergency temporary standard, but there is public comment available now. For whatever purpose that might serve. And they're saying, and this is, sort of a nod to the Supreme Court precedent, they're saying if there is a government entity that can compel vaccination, which of course the ETS is not doing, it rests with the states and not with the federal government. So who's ultimately going to decide? There was a lottery yesterday, and the 6th Circuit, which is our circuit based in Cincinnati, was picked in the lottery. They're the ones that are going to hear all of these appeals and everything that's been pending in all the other jurisdictions. They will decide what happens with that 5th Circuit injunction that is in place. That injunction has never been clear about whether it only applies in the 5th Circuit, which is Texas, Louisiana, I think Mississippi, southern jurisdictions, or whether it is a nationwide injunction. But the 6th Circuit is going to presumably issue something to clarify those issues. I just looked this morning, there's no schedule yet, other than somebody moved to have an en banc hearing in the 6th Circuit, which is basically to have all judges assigned to the 6th Circuit hear this case. From a procedural standpoint, that there's no basis for that. En banc review is usually comes about when either a panel, which is typically 3 judges on an appellate court, issues an opinion where, you know, somebody thinks there's something clearly wrong about it, and so they say, hey, the whole court needs to take a look at this. Or sometimes that's granted when the panel, the 3 judges who initially hear a case, issue a decision, but there are other circuits that have handed down decisions that are the exact opposite. Sometimes there's an en banc review there, but in this case, it seems highly unlikely that there's going to be an en banc review because, first of all, it's going to tie up the dockets of every judge in the circuit as opposed to just 3 judges. So I don't think they're going to do that. And what everybody knows is that no matter what happens here, this case is going up to the Supreme Court. So it doesn't matter whether it's a panel, en banc, whatever, it's all going to the Supreme Court. And of course, what this means is there's going to be a lot of timing pressures on employers because this process, even though it may be expedited, it's not happening next week. It's probably not happening the week after that. And then we're starting to get into, you know, deadlines that are pending under the ETS. So let's talk just about some, because the ETS may not impact all of you. It probably only impacts a few of you. So let's just talk very quickly about some questions that come up about vaccination in general. Can we ask employees about their vaccination status? Yes, 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 yes. You can ask them, are you vaccinated? What we suggest is that if somebody says, no, I'm not, you do not want, particularly your managers, you do not want to be saying, well, why not? Because that could be getting into a medical inquiry. Now, you can certainly say, if you're not vaccinated, if you're going to impose, for example, you're thinking about having a mandatory vaccination policy, you can say, listen, anybody who can't comply with this, if you need an accommodation for medical, religious reasons, you know, please contact HR, please fill out this form. You can certainly do that. Can we require them to provide proof of vaccination? Yes, yes. And I would suggest to you that that would be a wise thing to do. Because there's likely to be spikes in cases now that we're getting into the winter. You may have sort of okay, well, if you told us you're vaxxed, we're going to trust you and you don't have to mask or you don't have to quarantine or whatever other implications there are for that, but you don't actually have proof of their vaccination. It's time to get past that. My strong recommendation to you is to require proof from people who say that they're vaccinated. The OSHA ETS, even if it doesn't apply to you, lists like 5 different ways that people can provide proof of vaccination. So that's available if you want to have alternatives to the Vax card, which you should in case somebody lost it or whatever. Can we have different rules for people who are vaccinated and non-vaccinated? Yes. You can require non-vaccinated people to wear masks. You should have different rules about quarantine. If you do contact tracing, if somebody's been in contact with somebody with COVID, there are different CDC guidelines for people who are vaccinated versus those who are not vaccinated. Who can know about somebody's vaccination status? Now, you know, this is something when somebody shares with you a copy of their vaccination card or their vaccination status, you should treat this as a confidential medical record, just like you would with a FEMLA certification or other kind of medical information, separate part of the personnel file, need to know basis, you shouldn't be a roster posted on the front door of who's vaccinated and who's not. But sometimes you have to share that status with, is there someone who's tasked with enforcing people who need to be masked and people who do not need to be masked? If somebody's responsible for that in your office, they can't enforce that if they don't know who is vaccinated and who isn't. So those are things that that would be a need to know basis, but it really needs to be need to know. Are Vax cards protected by HIPAA? Unless you got them from your plan, then they're not protected by HIPAA. They're still confidential medical information that you should treat the way you would, you know, anything else in sort of the normal course of business. Okay, pay for time testing. If you're going to implement testing for your employees, or you're required to do it under the ETS if it goes into effect, there's a lot of confusion about whether or not you have to pay for the time that they take to test. ETS, again, because they really just want people to get vaccinated, the ETS says, hey, we're not saying anything about whether or not you have to pay employees for the time they take to test. And so they just absolved themselves of addressing that issue at all. But they said, listen, you do have to comply with other, laws out there that may apply to this, which of course would include the Fair Labor Standards Act for your non-exempt hourly employees. Do they have to be paid? Now, what I would tell you is, I think it's pretty clear. If you were to implement a testing program at your work site, Susie, when you show up on Tuesdays before you start your shift, you need to be tested pursuant to our testing policy or what have you. That time at the workplace being tested, regular working day, that time is compensable. What the FLSA, the guidance that came out previously before the ETS, said that if employees are doing testing and it's quote unquote necessary to perform their job safely and effectively during the pandemic, then that's compensable time. There's not a lot of guidance on, well, what does that mean and how does that apply to this testing? My sense is if it is covered by the ETS, I think it falls within that FLSA definition, and so I think it's probably compensable. Now, the DOL is supposed to be providing some additional guidance on this. My sense is they're probably going to say that it's compensable time, so that's something to think about. And then obviously, if you're in states outside of Ohio basically follows FLSA. If you're in states outside of Ohio, which probably most of you probably are not, you have to also consider whatever the state law says about these issues. What about paying for the actual test? I mean, you have all the issues that I think Julia talked with you a little bit about earlier this morning. The ETS says that employers are not required under the ETS to pay for the cost of the test. So that's their, what they say, but they say, hey, if you have a collective bargaining agreement, if the state law where you are requires payment for tests, you need to comply with whatever you need to comply with. What if you're paying for a test as an accommodation? So you have a mandatory vaccination policy. Somebody says, I have a disability. They jump through the hoops. They give you the documentation. They have a medical request for accommodation, and the accommodation is to provide the test. You are going to need to pay for that test. If the accommodation is a religious accommodation, and let's say you've got 20 people in a relatively small organization with a small budget who have a religious accommodation, you can go back to that. Is it more than a slight burden for you to pay for the test? And you can potentially hang your hat on, yeah, it's okay if you test, like we'll let that be the accommodation, but it's more than a slight burden. We're not going to pay for it. You employee have to pay for it. Do you have issues with minimum wage? Potentially, if you've got minimum wage workers and they're shelling out 30, 40 bucks for a test, and that would then take their sort of like hourly wage below minimum wage when you include that expense, that can be an issue. Ohio, just so you're clear, does not, some states have specific statutes dealing with medical tests and whether employers have to pay for them. Ohio does not address it, but there's a lot of issues that sort of fall out of that, in addition to the benefits related issues that Julia talked about. Okay, documentation requirements. Now, again, this is for people who are covered by the ETS. If the ETS goes into effect, you have very specific requirements that you have to implement policies. There are notice requirements to your employees. You have to be gathering documentation. You have to have an employee roster indicating who's vaccinated, partially vaccinated, not vaccinated, getting an accommodation. All of that stuff has to be tracked. It needs to be up to date. Testing results have to be tracked. And if OSHA knocks on your door, you have to produce that in 4 hours. So, if you have pieces of paper being shoved into people's files You may struggle with meeting OSHA's demand if this goes into effect and turning all that over in 4 hours. So be thinking about those sorts of issues. Accommodations, medical and religious. Okay, so as we said, if you are implementing a mandatory vaccination policy, you do have to take into account people who have either a medical condition or sincerely held religious belief that conflicts with that vaccination requirement. Okay, and so you probably started thinking about this if you've thought about having a mandatory vaccination policy. So medical accommodations, this isn't that different from what you've dealt with in the past. I mean, this is basically the ADA process, the interactive process. Somebody says they have a disability, you give them paperwork, you get it back from the doctor, you take a look at it, you decide, is there an accommodation available, et cetera. This is probably pretty routine for you. Now, I will tell you, I talked to a client yesterday who got a medical accommodation where doctor says, you know, Jim has a belief that, you know, whatever, something about the vaccine is going to impact something related to his health, signed, you know, Joe Blow, MD. And the client was talking to me about whether this is an accommodation, like, is this sufficient support for a medical accommodation? My answer, quite frankly, was no. I mean, if Joe Blow doctor wants to say it's Joe Blow doctor's professional medical opinion that this employee should not be vaccinated due to whatever medical reason, even if it looks completely hokey, I'd probably say, like, okay, you know, good enough. We're not going to challenge that. We're not going to go get a second opinion, you know, whatever. But just a doctor signing that some employee has a belief based on something he read on Facebook that this isn't good for him, that to me does not meet the medical accommodation requirement, my opinion. Okay, so we have a couple quiz questions to talk about accommodation issues, particularly in the religious context, because these we're less familiar with and they're more difficult. So Darren is an employee of XYZ company. He's been telling everyone who will listen to him for the past year he's not getting the vaccine. He thinks it's a ploy by the Democratic Party to change his DNA and make him a liberal. XYZ has mandated the vaccine and Darren applies for a religious accommodation. He tells HR that it is his quote unquote God-given right to make his own medical decisions and his sincerely held religious beliefs do not permit him to be vaccinated. XYZ says, please provide us with a letter or documentation of your belief, and Darren fails to provide that because he doesn't belong to a formal church. Should XYZ excuse him from vaccination? A, yes, because he said this is his religious belief and employers have no grounds for questioning an employee's belief. B, no, Darren clearly has a personal or political belief that is not dictated by religion. C, no, if Darren fails to demonstrate that the objection is based on a sincerely held religious belief. Or D, no, because Darren hasn't provided documentation from an outside party so the accommodation can be denied. So should he be excused from vaccination? What do you think? A, B, C, or D? And we did this in a seminar that we did a couple days ago. We had we had a variety of responses. So I will tell you, for those of you who said C, that is the correct answer. Let's talk about why the other ones are incorrect first. Okay, so should they excuse him from vaccination? Yes. I would say no, because the reason this answer is not correct is because employers can question an employee's belief. Now, how far you dig into what is sincerely held, you know, it's a tricky situation, but you can dig a little bit. And we set this hypothetical up with Darren having said, you know, for a year that he's not getting it and it's, you know, a political or whatever belief. It's not religious, is what he's been talking about. So there's a basis for questioning. Is this really religion or is this something else? Okay, B is not correct. Even though he has stated a personal political belief, he could also have a religious belief. So you could have both. And so it's not clear at this point, is it religion or is it not? D is incorrect because you can have a religion of one. I can have the religion of Nancy Barnes, and my religion can tell me whatever it is that it tells me about vaccinations or testing or whatever else. And you cannot challenge it by just saying, well, I've never heard of the religion of Nancy Barnes. That's crazy. No, that's not, and you can't make me get a letter from a minister, priest, rabbi, whatever. That cannot be the requirement. But you can require a demonstration that it is a sincerely held religious belief. And so if he doesn't respond to questions and also doesn't provide any documentation, et cetera, then it could be denied on that basis. So religious accommodations, again, you don't have to have a formal religion, you don't have to have a group who all believe in the same thing, but at the same time, you do not, as an employer, you do not have to accommodate personal, social, political, economic beliefs related to vaccination or testing. So again, here, and these slides are going to be shared with you after the presentation. I'm not going to go through all of these different points, but these are some bullet points related to dealing with religious accommodations if you are going to sort of question the sincerity of those beliefs. So next quiz question. XYZ determines that it's not going to challenge Darren's sincerely held religious belief. So it begins to consider accommodations. Darren cannot work at home and must be in the workplace. Okay, and again, they're requiring vaccination. Darren has told his supervisor that he's willing to test weekly, but that it's a religious accommodation, so the company has to pay for it. XYZ approves the religious objection for about 25% of its employees and is facing a significant weekly cost to test those employees and track results. So therefore it says, listen, this costs us too much. It's more than a slight burden. And so they said, we are not going to pay for testing. And so they placed him on indefinite unpaid leave. Can they do that? A, yes, because they're facing a significant cost and they can deny the accommodation on that basis. B, no, they cannot deny because they're in a better position to pay for the cost than the employee. C, no, they cannot deny it because they can't make a decision that imposes a cost on the employee, i.e. putting him on unpaid leave due to his religion. Or C, yes, if they still doubt that this is truly a religious accommodation request. What's the correct answer? Think about it for about 2 or 3 seconds. Okay, let's go through the wrong answers. Okay, they've already said he's got a religious accommodation request that they've approved. So D is not the correct answer. If they're still questioning if this is truly religious or what have you, they need to go back to step 1. They're now at step 2. Can they make a decision that imposes a cost on the employee due to religion? They can, because again, this is a religious accommodation. And if it causes them more than a slight burden, which is the current standard under US Supreme Court precedent, they do not have to provide paid for testing to the employee. The fact that they're in a better position than the employee, that doesn't change anything if they can show they have more than a slight burden. So A is the best answer. Okay, practical tips. We're almost to the end and I'm gonna turn it over to my associate, Hannah. And then I will look at the questions. Some of you have posted some questions in a chat and I promise I will come back to you and answer those questions after Hannah's presentation very quickly. But some practical tips, whether, even if you're not covered by the ETS because you have fewer employees, these are some things to think about. I mean, I do think additional requirements are coming that are going to apply to more employers than just those with 100 employees. There could be individual state or local requirements that come into play, particularly if we see a spike in cases. So these are some things to think about. Number one, for those of you covered by ETS, do not wait until this litigation is resolved to get started. You don't have to issue a policy, but start thinking about, if we have to issue a policy, what is it going to say? Start gathering information for your employee roster. How many of your employees are vaccinated? To try to make a decision about whether or not you're going to mandate vaccination, whether you're going to do testing, are you going to do testing on site, are you going to make employees do testing, whatever. To me, trying to make those decisions in a vacuum without knowing how many of your employees are vaccinated is somewhat foolhardy. So I would suggest to you get that information. Deciding, should we do mandatory vax? Should we have a test option? Should we do something else? I mean, there's a million different things that go into making that decision, most of which are not legally related, but dealing with, you know, your talent pool, key talent, recruiting, retention, all those kinds of things. Proactively communicate with employees. Everybody's asking questions. What is my organization going to do? Am I going to have to get vaccinated? Are you going to make the person who's sitting next to me get vaccinated because I want them to be vaccinated? All those questions. So being proactive in your communications is advised. Drafting policies that think through, what are you going to do if you put a policy in place and someone doesn't comply? Are you going to fire them? Are you going to put them on an unpaid leave and let them think about it for a couple of weeks before you terminate them? Are you just going to discipline them? Like, what are you going to do? Thinking through those issues. Designate a compliance person. I'm guessing if you're on this webinar, that person is probably you. Congratulations. So, but there should be somebody who is the point person. If you're going to do testing, you need to make a plan. Almost everybody who talks to me about these issues is talking about their struggles with finding a provider, getting testing supplies, thinking through how long it's going to take the lab to run tests for this many employees in the United States of America. You know, OSHA says they don't expect any issue. Well, I can assure you that I expect an issue. So be thinking about that. Have an accommodation process. It's really important to have consistency in terms of, if you're granting a religious accommodation based on stem cell, fetal cell, whatever, that religious exemption request, then that should be true for all employees who fall within that bucket, or none of the employees who fall in that bucket. Train supervisors and managers, particularly if you're sharing with them vaccinated status information because they need to enforce something or what have you, that is personal information that is not to be shared with other people. If they're getting questions from employees, who should they go to about these issues? And many of you, I'm quite sure, unlike some of my other clients who are in construction or in manufacturing, they're used to dealing with OSHA. You know, OSHA shows up frequently. Most of you probably, hopefully, have never had to deal with OSHA. Do your people know what to do when OSHA shows up? Do they know who to call? Do you know what to do if OSHA shows up? I mean, you do have some rights. There are things that they can make you do. There are things that they cannot make you do. So you may want to think about that if you're not familiar with that process, and at least, you know, not having your receptionist walking them over to the file cabinet and unlocking it and letting them go through it. So these are things to be thinking about. So I'm going to take a look at questions while Hannah covers her part of the presentation, and then we'll do a quick wrap up at the end. And thanks so much for listening. Hope this was helpful. And now I'm going to turn it over to Hannah Caldwell, who is an associate here in our Cleveland office. She is in the labor and employment group. She's phenomenal. I'm sorry you don't get to see her in person. She's a great speaker. I hope some of you get to know her when we get back to in-person presentations in the future, but I will turn it over to Hannah. I'll get out of her way. So sorry, we're doing a little shuffle here.
Thank you, Nancy. Good afternoon, everyone. As Nancy mentioned, I'm Hannah Caldwell, and I'm an associate in our Labor and Employment Office here in Cleveland. And I want to talk to you about a couple different issues today, beginning with drug testing, e-cigarettes, and medical marijuana, which is sort of an exciting topic for today. And as I'm sure a lot of you know, employers and HR professionals have had quite the headache navigating complex state law and court cases dealing with drug-free workplace and testing policies. So let's dig into those issues a bit. So possession or use of marijuana remains illegal under federal law, obviously, but state laws change rapidly, including some that now limit a company's ability to fire an employee for failing a drug test, which is a pretty recent development. And as you can see from this slide on the screen, state law treatment of both recreational and medical marijuana use varies widely by state. And as you saw on the last slide, marijuana's legal status is complicated. Employers need to start start this analysis by considering how state marijuana laws interact with their own policies and generally with federal law. So in some states, employers are not required to accommodate the use of medical marijuana at all. But on the other hand, in some states like Illinois and Pennsylvania, as you saw on the map, employees cannot be discriminated against for being registered marijuana card holders or because they test positive for marijuana on a drug test. And we'll talk more about some of your rights as the employers in a little bit, but you know, although your obligations and restrictions related to marijuana use vary widely, no law requires employers to allow medical marijuana use during work hours or to allow an employee to report to work impaired. And we'll discuss in a moment that employers may take adverse action based on any good faith belief that an employee used or possessed marijuana during work hours. So what's next? What should we do about all of these various state law and local laws? So in most states, employers can just continue to test their employees under their current scope of their policies. But it is important to understand the rules in each state where you operate. Employers need to consider whether state law protects employees' use of marijuana for medical reasons, and under some circumstances, may require employers to grant an employee's request for a reasonable accommodation. Now, Ohio law does not require employers to accommodate employees who use medical marijuana. But on the other hand, for example, Massachusetts disability discrimination law expressly entitles employees who use marijuana to treat a disability to a reasonable accommodation. In Nevada and Vermont as well, employers must engage in an interactive process and attempt to accommodate the reasonable needs of medical marijuana users. So, as I mentioned before, while Ohio law doesn't require employers to accommodate employees, it is important to understand how this landscape looks in other states as these laws are changing rapidly. As far as drug testing goes, employers can still discipline employees for being under the influence or impaired by marijuana at work or during working hours. As I'm sure you know, it sounds kind of funny to say, there's no test to differentiate between recreational and medical marijuana, and no test can determine exactly when marijuana was used, maybe in conflict with what your parents told you back in high school, but that is true. It's important to note that some courts have begun siding with workers who say that their off-duty use of cannabis for medical reasons led to their unfair dismissal. Some recent court cases have left employers facing discrimination charges for taking action against employees who flunk marijuana tests. As I mentioned, Nevada recently limited the rejection of job applicants for failing a marijuana test, and New York City recently voted to ban marijuana testing for job applicants, with some exceptions for jobs such as public safety workers. In states where recreational or medical marijuana has been legalized, employers may need to develop new drug testing protocols to determine marijuana intoxication based on behavioral issues and avoid traditional tests that detect THC remaining in a person's body for many days after using marijuana. And in that vein, a best practice would be for employers to educate supervisors on symptoms of medical marijuana impairment and develop a consistently applied procedure to document objectively observed behaviors. And it's also a best practice to have at least 2 members of management involved in that process. So let's switch a bit from medical marijuana over to e-cigarettes, which is another hot button issue that a lot of employers are dealing with in the workplace. Smoking obviously has been banned from most workplaces for a very long time, but vaping presents new issues for employers. And only 16 states and a number of cities and localities have expressly banned e-cigarette smoking indoors. But that sort of brings up the next question: what about employers that have facilities that are indoor-outdoor, or those states where the state or locality has not banned e-cigarette smoking indoors? The next step for employers is to understand that most employers are generally treating e-cigarettes the same way they treat traditional cigarettes, because it can arguably have similar effects on employee health and non-smoker employee morale. Employers should start by reviewing their state and local laws for any express restrictions on the use of e-cigarettes. But state laws aside, the next step for employers should be reviewing any clearly written policies that they have regarding smoking and ensure that their policy is consistently applied both to traditional cigarettes and e-cigarettes. Just because you've banned smoking doesn't necessarily mean that you have banned e-cigarettes. So it may be time to revisit that policy. So with all that said, we're going to switch gears completely and talk about another important topic. I'd like to give you a refresher on your organization's obligations with respect to employees in the military. Your other accommodation obligations under various federal and state laws get a lot of attention, but USERRA is often overlooked. So we'll take a quick look at USERRA and some of the federal court developments that recently came out interpreting the law. So to begin, USERRA is the Uniformed Services Employment and Reemployment Act, and it imposes affirmative obligations on employers to do a number of things, like provide employees with leave to serve in the military, to reinstate employees returning from the military, and to train or otherwise qualify those returning employees. Now, the Act also guarantees employees certain benefits, like a continuation at the employee's expense of health benefits for the first 24 months of military leave. And the next slide asks who's covered, and the answer is basically everyone. All public and private employers are covered. Unlike many other federal statutes that require an employer to have a minimum number of employees or a minimum size threshold to be covered, USERRA contains no such employee requirement. And likewise, all employees, both full-time, part-time, seasonal, if they have any expectation of returning to work, they're also covered under the law. And equally broad, USERRA's reemployment rights and benefits extend to all employees who are absent from work due to any service in the uniformed services. And that includes absences for active duty, inactive duty, reserves, in the Army, Navy, Air Force, Marines, National Guard, and others. It's very expansive, as you can tell. So one of those first affirmative obligations that we discussed on a previous slide is reinstatement. So once an employee returns from a period of leave, in order to be eligible for reemployment rights under USERRA, they need to satisfy a few criteria first. And they're pretty simple, but let's briefly go over them. First, the leave must have been required by reason of service in the uniformed services. So like we discussed before, that just means that the individual must have had appropriate leave orders. Second, employees are required to provide advance notice to their employer on their military service obligations. This notice can be oral or written. There's no formalities really that are required. They just have to let you know basically as soon as possible. Third, under USERRA, the cumulative length of an individual's military leave may not exceed 5 years. And there are some exceptions to that factor to the 5-year rule, but they're pretty niche, so we won't go over them, but note that I did tell you that there were a few exceptions. Our fourth factor is the employee needs to reapply. Under USERRA, the time limits for returning to work depend on the duration of an individual's military service. And again, like we discussed in the second factor, there's no real particular form or secret sauce for this reapplication. The message simply needs to be, I used to work here, I left for military service, and now I'm back from service and I want my job back. and that can be orally or in writing. Put another way, you don't need to treat the returning service member as if they were a person who was reapplying for a completely new position, or someone who was applying for a job for the first time with your organization. And finally, USERRA requires that employees completed their military-related service under honorable conditions in order to be eligible for reemployment rights. So if an employee met those requirements we discussed for reinstatement on the last slide, the employer has an affirmative obligation to reemploy them. But importantly, the regulations require employers to utilize a concept known as the escalator principle. Under the escalator principle, the individual is entitled to reinstatement to the position they would have attained with reasonable certainty if he or she had not gone on military leave. So this can this can have a couple implications on the job where the individual is replaced. It may result in non-automatic discretionary promotions or other advancement, and it may require training that employee to function in a new position. But it can also have the opposite effect. The application of the escalator principle can result in adverse consequences when an employee is reemployed. For example, the regulations provide that if an employee's job classification or seniority would have resulted in the employee being laid off during the period of service, and the layoff continued after the date of reemployment, that employee would be properly reinstated to layoff status under the escalator principle. So like I said, the application of the escalator principle can result in a promotion, reorganization, a layoff. It can also depend on the economic circumstances that the organization is dealing with. And now that we're caught up on the foundational issues under USERRA, I'd like to talk about some recent developments in federal court. You may have noticed that I haven't said anything about pay, and that's because employers are not required to compensate employees absent due to military service. But in two recent cases, one in the Seventh Circuit, which serves Illinois, Indiana, and Wisconsin, and one in the Third Circuit, which serves Pennsylvania, New Jersey, and Delaware, employees returning from short-term military leave sued their employers after they were not given the same pay and other benefits that were offered to employees who missed work for other reasons, like jury duty or illness leave or some other type of involuntary absence. So both of those courts examined the rights and benefits language in USERRA. And that language requires employers to furnish the same terms, conditions, and privileges of employment to employees on military leave as it does for employees on non-military leave. And the three relevant factors in that analysis include, first and most importantly, the duration of the leave, second, the purpose of the leave, and third, the controllability of the leave, or can the employee control whether they go on this leave or not? And in employing that analysis, both the Third and Seventh Circuit courts determined that paid leave is indeed among the rights and benefits covered under USERRA. So in light of these developments, employers can expect more litigation around unpaid military leave, and soon they may be required to provide the same pay and benefits as they do to individuals taking jury duty, illness leave, or other involuntary leaves to employees that go on military leave. At this point, what is most important for employers to understand is that they should review and develop consistent short-term leave policies and determine if your existing short-term leave policies, like your policies for jury duty or illness leave, are comparable in duration, purpose, and controllability to military leave. And this is important because the potential exposure arising from any non-compliant policies is amplified by the fact that USERRA generally has no statute of limitations, which makes it critical for employers to review their policies as soon as possible to limit any potential risk. And with that refresher, I will hand things back to Nancy, and she'll take some questions from you. Thank you very much.
Awesome. Thank you so much, Hannah. I'm going to address we're almost to the end of our time. Just want to address a couple of questions that came up in the chat that I'm able to answer. So one person asked, if an employee is not vaccinated and they're going to wear a mask in the office, what are we allowed to disclose for meetings with that particular employee? We also have events. Does that employee need to disclose their status to attendees? What I would suggest is you need to have your policy be whatever it's going to be. If your policy is that, listen, anybody who's unvaccinated in the office, if they're not in a closed personal office with the door shut, they have to wear a mask at all times, then, you know, if that person is let's say they're the only person who's not vaccinated, you know, they show up to a meeting and they're wearing a mask, yes, but probably most people can put 2 and 2 together and come up with 4. Although some people who are vaccinated, you know, choose to wear a mask anyway. They may conclude that that person is unvaccinated, but I would not recommend saying, we are about to have a meeting with somebody who's, you know, unvaccinated, and you know, like, or, you know, Hannah is unvaccinated, just so you know, she's coming to the meeting today. If you want to have some sort of blanket warning to people who maybe have a higher level of sensitivity, including attendees at your event, you know, you can certainly share information. For example, we put on an in-person and virtual webinar on Tuesday. We told people, listen, if you're coming to Thompson Hine's offices, you have to wear a mask regardless of whether you're vaccinated or not. But anyone who chose to attend in person would know we were not checking people's vaccine cards on the way in. We were not saying you can only come if you're vaccinated. So if you are an attendee, you would know, listen, if you don't want to be somewhere where you might be sitting next to somebody who's unvaccinated, who is wearing a mask, then you probably don't want to come to our event. So I think it's probably about the communication, but I would not single out and say, just so you know, Hannah's coming to this meeting, she's not a vaccine. And I'm picking on Hannah because she's standing here staring at me, but and I'm not disclosing anything about Hannah's personal medical information. Okay. Someone asked, can we ask interns and volunteers the same question about, I'm assuming the question is, can we ask them if they are vaccinated? You can. You can ask visitors to your offices or facilities if they are vaccinated. You can say, you can only be a visitor here, if you have a vaccine card. You have to show us your vaccine card to enter the premises. I mean, you can do that. So hopefully that answers that question. Someone asked the question maybe before I said this, or maybe I wasn't clear. They asked, I was under the impression that OSHA has suspended ETS enforcement. Is that not the case? That is the case for the person who asked that question, but what is not clear is OSHA has not said, we're standing down, we will never enforce the ETS. They're just saying they're not enforcing it right now. That could change the day before those obligations go into effect, which is December 6th. If the court has not, stayed enforcement. Obviously, if there is a federal judicial order that includes an injunction saying that it cannot be enforced, I would firmly expect OSHA to comply with a federal court order or a Supreme Court order in that regard. It is also possible, please be aware, that portions of the ETS could be under review by the courts as potentially being unconstitutional, where other portions of the ETS, they could say, yeah, we're not staying enforcement of this. So there could be sort of a mixed bag, which is why for those of you who are potentially covered by the ETS, I really strongly recommend starting to gather information and getting your ducks in a row so that you are in a position to comply should it not be enjoined or found to be unconstitutional. So I think that covers, oh, no, there was one more question. Good question. Someone asked, are there considerations about using pronouns on business cards or in an email signature block as an organizational policy? Should it be opt-in? Should it be opt-out? I do think there are considerations, to think about, not necessarily legal considerations, particularly if you give people the option of choosing whether or not they want to include those pronouns on, a business card or not include them or not include them in their signature block. If you give people the option to opt in or opt out, to me, that would not create any significant issues, but providing that option is certainly something that I think a lot of employees would like to have the option to be able to include that. So if your current template or format doesn't include that and you're updating it or what have you, that may be a really good thing to consider including as an option for those sorts of things. So I think that covers everything for today. We're up against our time. Thank you for paying attention. I know a webinar for 3 hours is a really long time, and most of you have hung on for almost all of it. So thank you so much for attending. We are going to be sending out the PowerPoint slides to everybody who registered. So you will be getting those in your email today or tomorrow, most likely. I think they'll be coming from either GoToWebinar or from Thompson Hine. If you have questions, feel free to reach out to any of us who presented today. We're all our names at thompsonhine.com. You can look us up on the website or get in touch with Monica. She can push you in our direction. And hopefully this was helpful to you. I miss seeing all of your faces. I look forward to seeing you hopefully in 2022. And please have a wonderful Thanksgiving and holiday season and stay safe. And hopefully we can gather together in 2022. Thanks so much for attending. Have a great day. Bye-bye.